Good morning, everybody. It is Friday Eve. Happy Thursday. Welcome to the Courtroom Files Live. Let's start our day in Washtenaw County, Michigan. Judge Cedric Simpson, where undoubtedly bonds will be continued.
Court of hearings matters. Thank you, sir. This court also does not believe there's a conflict either in the Michigan court rules or the cases decided thereunder. To the extent there is a conflict, that a conflict does exist, given the waivers, the court will consent to hear the matters. Court does call the case, people of the state of Michigan versus Omar Smith. Morning.
And good morning, Your Honor. Joseph Hall, appearing for and on behalf of Mr. Smith, as well as
Good morning, Your Honor. Michael Vincent on behalf of. Why do I get both of you?
Jan and Men.
I'm sorry.
Just a lucky day, Judge.
Yeah.
Just a lucky day.
Just start out. All right.
Your Honor,
Is Mr. Smith here?
Yes, sir.
Mr. Smith, could you state your name for the record, please?
Omar Smith.
Thank you, sir. All right, what are we doing?
Your Honor, we've spoken with counsel. As you know the nature of this case, there's an extensive amount of discovery that's outstanding. We have communications on that. I know he's doing his best to facilitate the same. We would ask for an additional adjournment of the PCC date to accommodate that discovery process.
Okay, so there's more discovery to come that hasn't been obtained and.
Exactly. Yeah.
We just got the autopsy report, Your Honor. The slugs that were pulled out of the car still at the MSP lab in Northville. When they're done there, they have to go to Detroit for ballistics. So there's the investigations.
Okay. How much more time are we looking at?
I would say at least 4 weeks.
I agree.
Mr. Vincent, did you want to? You don't care. All right. I'm just happy to be. Never mind. Is 13th. Why don't I adjourn it out to December 18th? See.
That date works with our calendar, Your Honor. Thank you so much.
Thank you. December 18th, 2025, 9 a.m. Bond continue. Well, thank you, Mr. Smith.
Welcome. Thank you, sir.
Court calls the case People versus Lloyd Sanders. Good morning.
Good morning, Your Honor. Gemma Dadish on behalf of Mr. Sanders. Mr. Sanders, can you please state your name for the record?
Lloyd Sanders.
Thank you.
Your Honor, there is an offer on the record. Wayne County's entire Zoom was filled up this week. I'm going to have to adjourn to be able to discuss that with him and get the plea form ready before his next court date.
The 4th, or you want the 11th?
The 4th should be good, Your Honor.
Probable cause conference will be adjourned December 4th, 2025, 9 a.m. Bond continue.
I'll talk to you tomorrow, Mr. Sanders.
Court calls case People versus Edward Byrne.
Good morning, Your Honor. Assistant Attorney General Carissa Williams on behalf of the people.
Oh, there you are. Okay, good morning.
Good morning.
Byrne?
Yes, Stephanie Cannon on behalf of Mr. Byrne, and he should be appearing by Zoom, Your Honor.
Byrne, can you state your name? You have it.
I think there's a person who makes it.
I'm here, Your Honor.
All right, state your name, please. Good morning.
Edward Stewart Byrne.
All right, thank you.
And Your Honor, we're going to ask for just one more adjournment in this particular matter. He just recently received actual paperwork from the friend of the court stating he may have be overpaying. And I want to take a look at that before we potentially waive it up to circuit.
He overpaid or is overpaying?
They're going to relook at it because his W-2 makes substantially less, and he has been making substantially less since the order was entered. So they're trying to figure out what went wrong. At least that's what it looks like based on the paperwork I received. I want to just be able to review it and see what's actually happening in the front of the court case.
All right. Madam Attorney General, you know anything about that or?
Not, Your Honor, but I have no objection.
All right. Want the 4th or the 11th?
Your Honor, the 11th would work better. But like I said, once that's done,
would.
we'll likely just be waiving the very next day.
Probable cause conference will be adjourned December 11th, 2025, 9 a.m. Bond continued.
Thank you.
Thank you.
Thank you, sir.
Call the case, People versus Terrence Ginyard.
Morning, Your Honor. Assistant Attorney General Carissa Williams on behalf of the people.
And Assistant Public Defender Jay Bellinger on behalf of Mr. Ginyard, who appears via Zoom. Your Honor, Mr. Ginyard, can you please state your name for the record?
Terrence Ginyard.
All right, you need to turn on a camera, please.
I'm trying to, Your Honor. 1 second, sir.
Apologies, Your Honor.
All right, there he is. All right, he's waving.
He is waiving, Your Honor. There was an offer made in this case, and we just need to get his bond applied to the arrears at this point. But the offer is, if you don't mind that I read that on the record, if he begins paying his ongoing support and pays the arrears down to $7,400, approximately 25% of the arrears, which he's already done, and pleads guilty as charged, the AG will ask the court to place the defendant on a delayed sentence under 771. If he continues to pay his order during delay and pays the arrearage down by 50% to $5,000, the charge will be reduced to attempted felony non-support. And if he pays the arrearage in full, the charge will be reduced to disorderly person or non-support. With that understanding, Your Honor, we will be waiving the preliminary examination.
And that's a correct statement of the agreement.
Yes, Your Honor.
Yes,
All
sir.
right. Mr. Ginyard, you're waiving your right to a preliminary examination. You understand that that's a proceeding where the people would have to show by probable cause that the offenses alleged were committed and that you committed them.
Yes, Your Honor, I understand.
And you understand that you'll not have that hearing and that you'll proceed to circuit court for further resolution on this matter.
Yes, sir, I do.
All right, people also waive their right.
Yes, Your Honor.
Preliminary examination having been waived, defendant found over to circuit court on both counts.
Your Honor, we acknowledge receipt of information, waive formal reading, stand mute at this time.
Defendant having waived formal reading, standing mute, court will enter a not guilty plea. Pre-trial will be set for
January 6th at 1:30 with Judge Cunky.
January 6, 2026, 1:30 before Judge Cunky.
Thank you, Your Honor.
Thank you.
Bond will continue.
Thank you, sir.
Have a good day.
You do the same. Court calls the case People versus LaRon Moore.
Good morning, Your Honor. Michael Vincent on behalf of LaRon Moore. Please approach it.
Your name, sir?
LaRon Moore.
Thank you. You're requesting an adjournment?
Yes, Your Honor. We have numerous videos still review. At the appropriate time, I'd like to make a bond motion too.
All right. Adjourn this matter to December 11th, 2025, 9 a.m. without objection. As to bond.
Right now, his bond is $25,000 cash or surety. I'm requesting a somewhat lower bond, maybe a $15,000 cash or surety, 10%, if that is within reason.
Response from the people.
People would object. Bond is set relatively low considering the nature of the offense. This is an armed robbery and a home invasion charge. The defendant does not have significant criminal history, showing just a misdemeanor, possession of a master key, a motor vehicle, and that a juvenile driving with a license suspended was dismissed. However, based on the nature of the offense and the danger to the community, people would object to any modification of bond.
Anything else, Mr. Vincent?
He would be tethered to his mom's house, all appropriate conditions.
I would agree that, quite frankly, that bond is set low, given the fact that the defendant is facing a capital or life offense, potential life offense. So the court believes that bond is, I'm not going to raise it, but that the bond is set appropriately and deny the request for a bond reduction. Bond will continue.
Talk on the phone. Thank you, Your Honor.
Court does call the case People versus Denicia Charles.
Rob Dowers is
Good morning, Your Honor. Christina Sachs is standing in
for Edward Drukes with Ms. Charles Constant, is that correct? Ms. Charles, please state your name for the court.
Denise Charles.
All right, thank you.
Your Honor, we're asking for an adjournment.
Without objection, probable cause conference will be adjourned to December 11th, 2025, 9 a.m. Bond continue.
Thank you, Your Honor.
Court does call the case People versus Charles Hudson.
And good morning, Your Honor. Christopher Coyle, the attorney on behalf of Mr. Charles Hudson. I say that because I understand there's a Christopher Coyle on the docket today as well.
Oh, I thought that was you.
No, never mind. Mr. Hudson, can you state your name for the record? Charles Hudson. Judge, we're here for the PCC, and the prosecutor and I are attempting to get perhaps some type of resolution here at the district court level before we move up to the circuit court. So we're just asking for a little bit more time and adjourn the PCC out.
The 11th, will that work for you?
Yes, Your Honor.
Probable cause conference December 11th, 2025, 9 a.m. Bond continue.
Thank you.
Thank you. Court does call the case People versus Shane Edgesier.
Well, Your Honor, Saxon for Shania Desir is present to my race. Please state your name for the court. Shania Desir. I'm sorry.
Kenneth Overwater, Assistant Prosecuting Attorney.
All right.
Your Honor, we're asking for an adjournment. I have not received any discovery yet.
Okay, this is part of the new system and discovery.
Yeah.
Problem. Well, I'll ask it later. I'll just go December 11th, 2025, 9 a.m. on this. Bond continue.
Thank you, Your Honor.
Thank you, Your Honor.
Court calls the case People versus Marissa Dix.
Good morning, Your Honor. Robert Ellman with and on behalf of Ms. Dix.
Her name?
Good morning, Your Honor. Marissa Dix.
Thank you.
Your Honor, may we approach in this matter?
Sure, I'm not busy. Come on.
Thank you, Your Honor.
Good morning once again, everybody. Happy Friday Eve. Welcome to the Courtroom Files Live. I hope you are all having a great start to your day. Hello, Ellie. I need to see what I'm doing. Thank you, sweetheart. Let's, since they're muted, let's go down to Judge Glazer, Miami-Dade, and we'll say good morning to her.
You're going to have to show the money used to post your bond is from a legitimate source of funds. Thank you, Ms. Leon. Good day.
Tendrá que demostrar que el dinero para pagar fianza viene de una fuente legítima. Gracias a la licenciada León también. Buen día.
Thank you, Judge. Thank you. Let me call up now Yaseli Heroet, please.
Morning, Your Honor. Orlando Rodriguez on behalf of Ms. Heroet.
Do you want to work to your clients here so she knows you're here?
Sure.
She's coming, Your Honor. Thank you.
Courts of habit.
We're not the only one. Everybody does. You should be waiting for your client.
Yeah, that's what we usually do, right? We approach the bench and just say, "Ready?"
Good morning, ma'am. Do you speak English?
Yes.
All right, you were arrested pursuant to an arrest warrant charging you with organized scheme to defraud, a first-degree felony, grand theft, a first-degree felony, offenses against computer users, a second-degree felony, false entries in books of business entity, a third-degree felony. Your attorney is present. Good morning. Please state your name.
Good morning, Orlando Rodriguez on her behalf.
Good morning. The state is here. What is your name?
Good morning, Elvie Medina Marcus on behalf of the state.
And how would I spell your last name? I'm sorry.
Medina Marcus,
Marcus.
M-A-R-C-U-S.
Thank you. Okay, is there an agreement? First of all, I see a judge already reviewed this. It's this inside the warrant. This goes back to April 9th of 2025 when the case was investigated, and she's the former property manager for a condominium, I guess. What's going on?
Your Honor, it has been reviewed by a judge previously who set bond amounts for each count as well as a nebia requirement. Speaking to defense counsel today, I think the ask was, the state is requesting that everything remain the same. I think defense counsel's position is if we are at a point today where the Nebbia is satisfied, if we can recall it before your honor, because we are discussing documents that we have. We're not there yet, but that was like.
All Nebbia should usually be heard, vision check, but if it's resolved today. I'm happy to have-
Agree, Judge. My initial request, it's only a $4,500 premium. My initial request was going to be the court would remove the Nebbia requirement and give me 5 days to get it satisfied. But because Madam Prosecutor is being so available and reviewed the Nebbia, and now she's going to interview the affiant, I feel confident that we might be able to get that done this morning. By the end of your calendar, we could just say remove the Nebbia requirement. So we'll recall the cases.
So what is this? Go back to 2018 through 2021? Or longer?
The alleged offenses, she worked there longer. However, the offenses as alleged due to statute of limitations are between 2020 and 2023.
Okay. All right, so ma'am, you were ordered to stay away from the club at Brickell Bay at 1200 Brickell Bay Drive in Miami, Florida. You're not allowed to go to that business. You must stay away from there. Do you understand?
Yes.
All right, thank you. All right, so I'll set the bonds on the warrant. Anything you want to say about bonds?
No, Your Honor, no argument.
Other
On
than,
the yeah, we could just come back on that.
count one is a first degree felony organized scheme to defraud. It's a $15,000 bond. I'll put probable cause. There's probable cause for grand theft. Count two, a first degree felony, $15,000 bond. Count three, a computer uses offenses. It's a second degree felony, but the judge wrote $10,000. That's fair. $10,000 bond. And count three, the false entry of books of business, $5,000, plus the Nebbia requirement. Going to have to show the money used to post your bond is from a legitimate source of funds. All right. So if you come back and see me today, no worries. I'll be happy to address the Nebbia.
Thank you. We should have a response in 45 minutes. Thank you, Judge.
Thank you. Thank you so much.
All right, we can go back to Judge Simpson. They've unmuted. We can continue there for a few minutes.
She was going to take her bike to work, and it's going to be cold out there. So I think she should be able to take an Uber, see if we can draft or reset the exclusion zone so that a major thoroughfare she can take a major thoroughfare so she can get to work. And so that way she can tell the driver, yes, I can go down this road without fear that she's clipping the edge of the zone. All right.
Thank you, Your Honor.
So her bond is reinstated. I'll need an order with all the conditions. All right. She can be released.
Thank you, Your Honor.
Thank you.
Thank you, Your Honor. Thank
You're
you so
welcome.
much.
Court does call the case, People versus Desiree Gray.
And good morning again, Your Honor. Robert Elman on behalf of Ms. Gray, who should be here over Zoom. Ms. Gray, can you please state your name for the record?
There she is. Well, we see her finger. Oh, there she is.
Gray.
Thank you, ma'am. Go ahead. She's waving.
Yes, Your Honor, we're waiving. There should be a signed waiver in the file.
Ms. Gray, you're waiving your right to a preliminary examination?
Yes, Your Honor.
You understand that that's a proceeding where the people would have to show by probable cause that the offenses alleged were committed and that you committed them?
Yes, Your Honor.
You understand you'll not have that hearing, you'll proceed to circuit court for further resolution?
Yes, Your Honor.
People also waive their right?
Yes, Your Honor, there was an offer extended for this waiver.
Yes, go ahead, please.
My understanding of the offer is that the defendant is going to waive up and plead to 2 counts of possession of cocaine less than 25 grams under 7411 in circuit court.
And that's correct, Your Honor.
All right. Preliminary examination having been waived, defendant found over to circuit court on all 4 counts.
Thank you.
Mr. Elman.
We waive a formal reading. Sorry, Your Honor. Stand mute to the charge.
Defendant having waived formal reading, standing mute. Court will enter not guilty plea as to all charges. Pretrial will be set for
January 7th at 1:30 with Judge Conlon.
January 7th, 2026, 1:30. Judge Conlon. Bond will continue.
Thank you, Your Honor.
All right, thank you. Thank you, Ms. Gray.
Thank you.
Court does call the cases of the People versus Joseph Griffin.
Your Honor, Brandon Cook for the People.
Good morning, Your Honor. James Fifelski on behalf of Mr. Griffin on the file ending in 1698.
Assistant Public Defender Hannah Apple appearing on behalf of Mr. Griffin in the remaining three files.
All right.
Your name for the record, sir.
Joseph Person Griffin.
All right. Requesting an adjournment on these.
Yes, we are missing discovery on the three files that the PD office represents Mr. Griffin on.
And I'm still waiting for some video discovery that the prosecutor's office is preparing, so we ask for adjournment for that.
All right. And maybe this is the case to ask it on. Do we have any idea? I realize it's not anybody's fault that it's part of the new, well, it's not part of the new system, but there's a glitch or something. Do we have any idea when that's going to be resolved for discovery purposes?
I can give a more definite answer for the court in a few minutes, but my understanding is that there are fixes underway for the public defender's office to be able to receive the discovery, and we're working through that. And I think for private counsel, it's going very well. So we are just in the process of getting it. I think a timeline is probably next week we'll have it all sorted, but I'd be happy to get a more definite answer for the court in a few minutes.
Okay, if we could, but
yeah, for sure.
When you say it's working for private counsel, is that going to, if counsel's conflict counsel, are they grouped in with private counsel or?
Irritatingly, it depends. So.
Okay, that's definitive. No,
it has to do with the integration between the new system and the old system. That's where the sort of difficulty is. I'll try to give the court a better answer.
I spent some time on the phone with two people from each of the offices, both of whom had no idea what they were talking about, and I understood more. So they confused me more than anything in the world. All I knew is there was a problem at the end. All right.
I will work on that.
Okay. I should have just gotten to you because I knew. Okay.
For the Griffin issue specifically, some of it has gone through via email already, but there may just be more coming. I'll try to get for a better answer.
All right. What I will do is I will grant the adjournment. We don't just bring him back. Normally I'd go 2 weeks, but let's just do the 3 week. So I'm going to adjourn this probable cause to December 11th, 2025 at 9. And then hopefully things will be resolved. All right. Thank you, Mr.
Thank you, Your Honor. Your Honor, one more request. Would the court consider release to inpatient treatment? All of these cases, I believe, are related to substance dependence issues.
I don't have an issue with that. The public defender normally would prepare an order or a standard order. So if it's submitted on these,
I will send that to the court later today.
The only thing that has to be included in that is that if he's in custody and he's released that way, that there would need to be a tether run.
Okay.
Fair enough. Thank you, Your Honor.
Right. Thank you.
It's the Courtroom Files Live. It is Thursday. We're almost there, ladies and gentlemen, almost to the end of the week. If there is such a thing. I work pretty much 7 days. But for those of you who don't, enjoy the weekend that's coming up. Let's go to Jefferson County, Texas. We will say good morning to Judge Stevens.
Which carries with it up to 20 years in prison. So it's very serious. Wow. No big today.
Judge, this is my first.
You ever talk to him?
This is an initial setting. My first contact with him.
You got court. You were indicted in April. Did you know that? April. Yes. Well, 20 years in prison. So you're going to have to do your part to like get with her so that it's your life. She's not going to. Don't interrupt. Just listen closely. 20 years in prison is a lot. So she is going to represent you, but you can't do much without her help. You got to interact. We were indicted back in April. So this is already too old for me. So you got to start scrambling to get together to see what direction we're going to head. Do you understand? Is that a yes? So no. You're still at 3710, 3710. What's your address?
2349 North Street.
What's the zip there? 02. Ratings on the drives. Today.
Judge, I need a resetting so that I can speak with him about his media and his case and we can figure
Yeah,
out.
2 weeks, okay? To give.
Judge, I need. Or for
I want to
media
make sure he's
reports.
still around. Let's just review it in 2 weeks, okay?
Okay.
2 weeks and try to get with her. Reyes Castaneda. 2 cases. Okay, that's you, Mr. Castaneda?
Yes, sir.
You were charged with the 3rd-degree felony of evading arrest or detention with a motor vehicle, which carries with it up to 10 years in prison. If convicted, also you were charged out of that same incident with the 3rd-degree felony of having a prohibited weapon, apparently a machine gun. It was a Glock firearm that had been modified. And so I'm surprised the feds haven't gotten to you yet. They're probably looking for you as well for this offense. So good luck with both of these jurisdictions. You're looking at up to 10 years in prison for that. So there are consequences for not following the rules. It's always good to follow. You know, to spend time. What do you do for a living?
I was doing school, but I just started working like last Friday.
Doing what?
The company
For whom?
for the TCF company,
How much do you make an hour?
14 per annum.
All right. Have you had a chance to talk to this lady yet?
No.
She's your attorney, and she's a very good attorney.
Yes.
And it'd be wise to listen to her advice, but your choices have not been wise up to now on these 2 cases.
Yes.
Are you a citizen of the United States?
Yes, Mom.
Okay, because this could affect you if you weren't adversely, especially the prohibited weapon that the feds got a hold of, which they could do. You know, you get prosecuted in both jurisdictions. Well, it's not wise to make bold choices like this. How much time?
I need 4 weeks, Judge, to ensure.
I'll give you 4.
Thank you.
That's all I'm giving.
Thank you.
It's between 3. Get a refund. Jose Castillo.
Hi.
What's going on?
Okay, you have to fill all week. So even if this is 0, Judge, I have. So you're not doing this morning, but he is required as a translator, and he'll inform me that there is a translator coming around Tuesday. We will reset him to that time so that I can properly speak with him and advise him how to fill out that affidavit of indigency. That would be helpful to me.
You know, names and stages.
Well, things are relatively quiet. I want to take this moment once again to thank everybody this past week for their well wishes and everything. Most of you know at this point, on the last stop of our journey, my wife broke her leg in 2 places and had to have surgery before we could even come home. And she wanted me to pass along to everybody her thanks for all of the well wishes and everything. So very much appreciated. And thank you to all of you. So get on with it here, Judgy, so I can finish this hearing and see what else is going on.
You have a copy of this probable cause affidavit.
I do, Judge.
He speaks English.
He speaks.
Yeah, no, you're gonna respond no.
I don't
Of
believe.
course you do. That's what this states. That's what, you were highly intoxicated, extremely irate, attempting to outspeak me each time I explained the situation to me. Anyway. Are you a citizen of the United States? Resident. You know, this could adversely affect your citizenship, a felony offense. This is very serious. Have you had a chance to speak with her?
This is our first contact, Judge. It's an initial setting. I don't have any way to contact them prior or. And my reason for a request for a translator is because
He speaks.
legal issues are complex.
I understand.
I want to
I
make
want
sure
you to
that
speak
he's.
with him today and tell me what you can figure out about how much, but this, in light of this report, he speaks more English than you might believe, but make sure he understands what he's charged with. If we need to get a translator to help you, but his resident is. The way you handle this can affect whether you stay in this country or not, because the federal government can get this information and they can make a decision whether you stay in this country or not. That's why you have to follow the rules. Do you understand? It's very important. 4 weeks?
Yes, Judge.
All right. All right, get it reset. Manuel Hernandez. What happened here? Is this a party or something? Mexican Independence Day? It was
Sound right there.
everybody's Spanish today. You're Manuel Hernandez? You're charged with a state jail felony of unauthorized use of a motor vehicle. You had a chance to speak with Ms. McNally?
No, sir.
Do you work somewhere? Or where do you work? Employed.
Self-employed,
Doing what?
working on cars, tattoo.
You still live at 3031?
3031 40th Street.
How long have you lived there, sir?
All life.
This state jail felony carries with it up to 2 years in the state jail if convicted, and it's a felony, not a misdemeanor. So you've never been convicted before, have you?
No, sir.
You hesitated. You've never been convicted of a crime before.
Well, as a juvenile.
Were you treated as a juvenile, or
Yes, sir.
Were you handled as an adult?
No, sir.
They didn't transfer you to adult status? Okay. Well, what was the problem when you were a juvenile? What did you get in trouble for then?
Aggravated assault.
Well, not following the rules of law have consequences. That's why you've been through this before. The question is, why are you here now? Maybe it's a misunderstanding.
Yes, sir.
according to this, the police in Port Arthur were made aware of a stolen Cadillac. And they found it. You were driving it. And the owner said no one had permission to be driving his vehicle and he wanted charges filed. It had been stolen out of Houston. You were driving. You're in Port Arthur. So you need 4 weeks?
Yes, Judge.
Doesn't show if the vehicle was damaged or anyway. We didn't talk about that. And you're a citizen of the United States?
Yes, sir.
Okay. The only offense can affect your citizenship. If you are. All right, she's going to be your lawyer for the time being anyway. So make sure you keep in contact with her. She's very busy. Hold on. Can keep in contact with her. She doesn't have time to be searching and finding her clients. She's got a lot of clients, so keep in contact with her because she's going to be very busy here for a while.
Yes, sir.
So she's your lifeline. So follow her advice, okay? Get a resetting from that day. Thank you. Dominique Rubin.
All right, we'll keep an eye on Judge Stevens. Let's head a little bit to the west to San Antonio and start today's commitment to 9 to 11% more. Judge Boyd.
Good morning, Your Honor.
Good morning. How are you doing today?
All right.
Thank you for dressing appropriately for court. All right. So on this case, there is an offer that's due.
Judge, I came in here yesterday, confirmed with the state. She's not here. I'm sorry, I don't have her name. She told me yesterday that there was a intake prosecutor has given her new discovery. There was a phone dump that was done. So I'm having a USB device I'll leave with the state today so that I can get that discovery.
Okay.
So Judge, I know that an offer's due, but I don't even have all the discovery yet. And this case was just indicted in September.
All right. So is there any other outstanding discovery?
Where we 13, 18, I think that this was the last thing.
Yeah.
And I don't know the extent of it yet, Judge, but typically those are quite large files. So.
So first off, was there any CPS records in this case?
There are, and we have possession of them. Those should have been delivered to the defense.
Yeah, I need those as well, Judge.
All right. Did you, do you have a protective order for me to sign?
Yeah.
So for discovery, we have CPS records and those will be, are those going to be tendered today or you may need to make copies?
They can be tendered today, so you got USB.
I'm having it brought over, Judge.
All right.
I actually had it in my bag and I can't find it, so I'm having to bring another one.
And then the cell phone dump, you actually have that in your possession state?
To be honest, I'm not 100% sure. That's Ms. Jones's case, but.
Do you know if they have it in their possession?
About yesterday, then I take it with me.
Mrs. Jones indicated that the intake prosecutor just gave her that so that if I give the USB device today, she can give that to me and download it for me. Have it downloaded and I can pick it up.
All right. And I'm trying to think what else. All right, school records. Are there school records in this case?
I don't know, Judge. I know that I don't have school records.
All right, so state,
Yeah, good job.
if you can take this down.
Yes.
So I know you have the CPS records in your custody. The phone data is in your custody. Defense is going to bring USB to get that information from you. Since the nature of this case, if you all can make sure if there's some school records mental health records, and whether or not the defense is entitled to mental health records, y'all can have that discussion if anybody wants to file a motion. And I'm just going based upon the nature of the case that maybe that is there.
Thank you, Judge.
So if you'll check for school records, any type of doctor's records, and that includes mental as well as physical records. I'm sorry, physical health records.
Yes, Your Honor.
All right. All right, state, you all are going to need to confer off docket and make sure that the defense has everything. And you all need to confer off docket to tender an offer. And we are going to come back on December 11th to see where we are. And this will be a discovery setting. And most likely your jury trial will be in the new year if we come to that.
Thank you, Judge.
All right. Adriana?
Yes, ma'am.
Are you able to do a reset form?
Yes.
And it'll be for discovery and it's December 12th. I'm sorry, December 11th. All right, thank you.
Thank you, Your Honor.
Just have a seat. Once you sign the reset form, you're excused.
Thank you, Your Honor.
And you have,
I also have Fernando Trujillo, Judge. I do know that his federal setting.
oh, just 1 second. Let me find it on the docket.
Judge, that one, right here is on page 12 on the first one.
Let me pull this up. Yes.
The protective order.
Okay.
Thank you, Your Honor.
All right, so the last setting we were here, it says that the federal trial was set for October 27th. That's been moved.
It has, Judge. The next trial date is January 29th.
January 29th,
This is for trivia, right?
Yes.
This is for Trio, yes, sir.
Thank you.
And are you a part of this case as well?
That is our case. Well, there's one with us and then I think his one with CT as well.
All right. What I'm going to do, even though I know his federal date is 1/29/26, I'm going to call this back for the same date as the other case. And you all need to make sure that all of the discovery is given to them. So whenever the federal matter is taken care of, people will be ready.
Yes, Your Honor.
Thank you, Judge.
All right. It's going to be December 11th as well. And you can put it as discovery.
Thank you, Judge.
Okay, undoubtedly we'll be back to Judge Boyd at some point, but let's go down to Florida and we will say good morning to Wade Mercer and watch his first appearances.
Yes, sir.
Right, I'm appointing the public defender's office to represent you, ma'am. Please listen to Mr. McDaniel and we'll see where we go in this case.
Your Honor, I spoke with Ms. Richardson thoroughly this morning about this case. Went over the options with her about getting out of jail, possibly conditional release, possibly cash bond, possibly ROR, with no criminal history, a school teacher. And also went over the offer with her, Your Honor. And after discussions with her, she just wants to go ahead and resolve this case this morning. With the understanding that she'll be adjudicated guilty, 11 months, 29 days probation, $1,078 in fines, 50 hours of community service, DUI school. She'll have to take substance abuse counseling, double the amount normally, and probation will determine what that is. There'll be a minimum driver's license suspension for 6 months, and this will resolve this case today. She has signed a plea form, a right to jury trial and call witnesses.
Thank you, Mr. McDaniel. Mr. Mitchell, is that agreeable with the state?
It is, Your Honor.
Ms. Richardson, did you hear that agreement?
Yes, sir.
And Ms. Richardson, do you have any questions about that agreement?
No, so will I get all that information? No, sir, I don't have any questions.
All right, is this a plea you would like to enter, ma'am?
Yes, sir.
Ms. Richardson, I'm going to accept your plea of no contest to the one count of driving under the influence. To judge you guilty of that offense, sentence you to 11 months and 29 days probation. Florida law requires certain mandatory conditions for a DUI, Ms. Richardson. I've got to impose those. That's $1,078 court costs and fines, successfully complete substance abuse counseling. Since your breathalyzer, or this was a breathalyzer case, since the breathalyzer was over 0.20, I require twice the counseling, but your counseling, if you go through the DUI school, that's going to satisfy a vast majority of your counseling. That DUI class is 16 hours.
Yes, sir. So what we've been doing previously is if she enrolls within 60 days, not completes, but enrolls, they're running behind, then she gets 16 classes credit towards the 24, and she'll have 8 more of what you've done previously.
Thank you. So the class is basically an hour long. So when you go to the DUI school, that's 16 hours. So as long as you enroll within 60 days, that 16 hours down there, basically you get credit for 16 hours of class, and it would only leave you 8 hours of class left. Ms. Richardson, I'll have to, by state law, have to order 50 hours of public service work. And I do recommend the minimum driver's license suspension, ma'am. I believe that's going to be a 6-month suspension. Ms. Richardson, there's possible early termination. What I mean by that is it may be possible to get off probation early. Ma'am, in order to get off probation early, you have to do half the probation. So in your case, half the probation would be 6 months. And Ms. Richardson, you've got to get everything done to stay out of trouble. Now, DUIs, it's hard to get off early because state law sets the fine so high. But if you can get everything done early, then good for you. There's a good chance of getting off early. Sometimes that may take 6 months, 7 months, 8 months. But if you get everything done early, you'll get off early as long as there's no violations and you're in good standing. Ms. Richardson, what's going to happen next is this. They're going to let you use the phone if you need to. For transportation purposes, they're going to let you get dressed in your regular clothes. They're going to bring you to the courthouse. The reason for that is the courthouse is where the probation office is at. Once you get to the probation office, you'll meet with the probation officer. Mr. Goodson will go over the probation order with you. He'll give you a chance to ask any questions about the probation order. He'll give you a copy of all the rules in writing of probation, and then you'll be free to leave. I'm going to ask your parents and your family if you have transportation, someone's going to go to pick her up. Usually it's 30 to 45 minutes. She'll be downstairs in the county probation office. So your family says they've got transportation covered, Ms. Richardson. You don't have to worry about that. There'll be somebody here to pick you up when you get here. Do you have any questions?
No, sir.
Does the family have any questions? Mr. Mitchell?
Your Honor, I think you may want to address the possibility of an interlock device, given that the BAC was so high. I think she's pleading to an over 0.15, so there is a possibility of that. I'll put on the record that the state is not requiring that she get an interlock device, but I know the DMV may enforce that.
Did I ask you if this was agreeable with the state?
Yes, you did.
Okay. So Ms. Richardson, what Mr. Mitchell's talking about is.
I have discussed that with her, Honor, and I have discussed that, and I didn't ask the state, but it sounds like they may be wanting to drop it below 0.15. Is that accurate, Jake? Or, I mean, I did discuss that with her.
Not in this situation, given that it's over a 0.2.
So, Ms. Richardson, the state of Florida may make you do an interlock device, like the statute says that you have to, but that's to get your license back. That's not a condition of probation. The reason I don't make it a condition of probation is because we don't have reasonably accessible providers at a reasonable cost in this area. At least we have it in the past. But even though it's not a condition of probation, the state of Florida very well may make you do it to get your license back, to get your license straightened out. Ms. Richardson, does that change your mind about wanting to enter this plea, ma'am?
What was? Probation, right?
Yeah.
Regardless?
I don't think it changes her mind. I don't think, Your Honor, but I also advised her that, you know, the last few cases I've had, they've had to have special insurance that costs several $1,000s. You know, and I advised her that also that, you know, I don't know how the special insurance works, but maybe Jake knows, but I advised her that also. None of that changes your mind though?
I don't think so. I don't know about, I don't think so.
Ms. Richardson, is this still what you want to do, ma'am?
Yes, sir.
Okay. So, Ms.
Can we
Richardson,
do
your
it?
family will be here to pick you up, ma'am, in 30 to 45 minutes.
One
And,
second, John.
Sure.
Give me one.
Well, they're muted. Good morning once again, everybody. Welcome to the Courtroom Files Live. Happy Thursday. We're going to hang here with Judge Mercer for a little while, and then there's a whole bunch of other places we can go after that. I've currently got my eyes on about a dozen different courtrooms across the country. Decent amount going on today. We've got bond hearings and trials, and you name it. So we'll find stuff.
The 20th. Okay. Because I know we had some holidays in there. I didn't know if that affected it. Yeah.
Mr. Richardson, I've got several more cases I've got to hear from. If you want to have a seat, we'll come back to your case. If you want to think about it some more.
Think of it. Just have a seat.
Okay, thank you.
Sure. Next case is with a has friends or family here is Jeremy Collins. Mr. Collins, good morning. Mr. Collins, your mother and your fiance are both in the courtroom. Mr. Collins, you're accused of 1 felony and 25 misdemeanors. So I'm gonna go through those charges. The felony charge is 1 count of unlawful possession for sale or selling deer, which is taken in violation of Florida freshwater fish and game laws. Then you're charged with 9 counts of violation of Florida statewide bag limit. You're charged with 4 counts of violation of administrative code regarding hunting antlerless deer, violation of antlerless deer permits. You're charged with 4 counts of exceeding the antlerless deer bag limit. So one of those are bag limit, and one of those is taking them out of season when you can't. You're charged with 2 counts of taking a deer or other animal during archery season without an authorized weapon, in other words, by a firearm. 3 counts of unlawful to kill deer, doe, or fawn with less than 5-inch horns. And it appears 1 count of unlawful taking of deer at night with a gun and light. And lastly, 1 count of possession, sale, purchase of a animal that's prohibited by the commission. They're accused of selling deer meat. So you're charged with 25 misdemeanor charges and 1 felony charge. That's what I'm seeing here on this warrant and on this complaint filed by Florida Game and Fish Commission. I'm going to listen to the attorneys, Mr. Collins, and then I'll address your bond status. Mr. McDaniel, anything on behalf of Mr. Collins?
Yes, Your Honor. Your Honor, he does have a job. He's working. He's got an 18-month child at home. Obviously, besides that PTI that he got recently, he has no criminal history. So, we'd ask the court for some kind of reasonable option for him to get out of jail and, to come back and take care of this. And he's locally, he'll be back for any court hearings, Your Honor, sets, and he's not going nowhere.
Mr. Mitchell.
I think that's reasonable, but we would also want the added conditions of no hunting, no fishing, and no possession of firearms.
Okay, so let's take those separately. I'm going to set your bond at $5,000 on the felony charge based upon, it appears you're very cooperative. It appears that you admitted to most of the allegations. I'm going to set your bond at $1,500 each on the misdemeanors. So you have 25 misdemeanor bonds of $1,500 and 1 of $5,000. Your total bond is $37,500. Excuse me. The $37,500 is for the misdemeanors. When you add the $5,000 to it, that would be $42,500. Your total bond is $42,500, cash or surety. You can go through a bondsman. That's what surety means. The reason I'm setting you the bond is because of the sheer number of charges, and I would never consider a conditional release for someone with with 26 charges with this kind of evidence against you, significant evidence, it appears. So that's your bond. The next question, Mr. Mitchell's making a request for no hunting and no firearms, and you said something else?
Yeah, I said no fishing, but that's force of habit, just no hunting and no firearms.
So there's a request from the states for condition no hunting and no firearms. Mr. McDaniel, would you like to be heard on that?
Have anything objection against those? I would just object mildly to just because the number of fish complaints or hunting complaints that, $42,500 bond seems excessive for, someone with, really no criminal history and local ties, but just a mild objection, Your Honor.
I understand. I appreciate that. Mr. Collins, the sheer number of times you've allegedly done this and the evidence against you is why you're getting the bond. This is not a one-time incident. It does not appear. It appears you've admitted to multiple criminal actions based on the complaint that's been filed. I'm going to have a condition of bond that you not possess any firearms and that you have no hunting. You cannot hunt while this case is pending. So if you get caught hunting by law enforcement, that will violate a condition of your bond and you can go to jail with no bond. So Mr. Collins, your hunting days are over, at least for a little while, and we'll see what happens when you get over to circuit court. Let me see if anybody has any questions. Mr. McDaniel, anything on behalf of Mr. Collins?
No, Your Honor.
Mr. Mitchell?
No, Your Honor.
Does a family have any questions? So whether you go through a bondsman or whether he puts up the money himself, it's entirely up to y'all, but you have the right to go through a bondsman. And what they charge you, they negotiate. Usually it's around 10%, but that's up to the bondsman. 10% of that would be a little over $4,000.
And I've already got his firearms when all is said, as long as he don't leave them at home.
He just can't have access to them. As long as some friends or family can have them, he just can't have access. Okay. Mr. Collins, do you have any questions?
No, sir.
All right, sir. Wish you the best. Mr. Goodson?
Mr. Collins, you're still on PTI with Mr. Ham. You did check in for October 15th. Your next check-in date is November 15th. If you're in jail, of course, you won't be able to check in then. But if you do bond out, you need to make sure you come in and comply with your PTI conditions as set forth and see Mr. Ham this month, okay?
Thank you for clarifying that. So these charges allegedly occurred before you were on PTI, Mr. Collins, and since they occurred before, they can't violate your PTI. So if you don't post bond and you're in jail, then we're not going to be violated because you can't report. But if you do post bond, you need to keep reporting on that PTI so that you can get that case dismissed if that's what the state, I guess the state kind of has to do that because these happened before. Is that right, Mr. Mitchell?
Yeah, I guess.
Yeah, I don't think you can violate it for something like that. So, Mr. Collins, I wish you the best. You have something else? No, I said 1,500 per misdemeanor and then 5,000 on the felony. So it's 37.5 on the misdemeanors, 5,000 on the felony, 42.5 total. Cash or surety. All right, so that's it for individuals who have friends or family. Actually, it's not. We'll come back to Ms. Richardson at the end. The next case is Clyde Williams, Senior.
Judge, Judge, would you consider a cash bond on him? I'm trying to, have him. I don't know if you will or not, but I hate for him to see though.
So let me explain that to. I didn't mean to interrupt you. Let me explain that to his mom. So what if you go to a bondsman and they take 10%? Then that's their fee. They keep that. The advantage of a bondsman is some bondsmen may take less than that. They may say we charge 10%, but we'll take 5% up front and you pay us payments on the rest or collateral or whatever. On the other hand, if I convert it to a cash bond, then it's the same amount that you'd pay a bondsman. It'd be $4,250. The advantage to a cash bond is this: that money is held by the clerk of court until the case is over. If the charges against him were dismissed, that money is returned to whoever posted it. If the charges are not dismissed, that money by law is taken and put towards court costs and fines. So he's requesting a cash bond so that you don't lose the $4,250 essentially. Okay, Mr. Mitchell, what's the state's position on that?
I have no objection to a cash bond.
I have no problem with that. You've got a cash bond of $4,250. So to break it down for the jail, instead of it being $1,500 per misdemeanor, it'd be $150 per misdemeanor. And the felony be $500. That would add up to $4,250 cash. And there are some advantages to a defendant for a cash bond. I don't know if you can post it or you can post it for him, but that's an option he's requested. Okay. All right. Wish you the best, Mr. Collins.
Thank you.
All right, we're going to pause proceedings here for just a minute because Barbara was asking what the charges were. The long and the short of it, it appears he was taking deer illegally. Whether or not he had a tag for any of them took too many. It sounds like, if I heard it correctly, he was like selling it as well. So that's where some of this comes into play. Even if you have your own land, you are not allowed to just take deer on your own land. Dates back to, English common law. The wildlife is referred to as like the king's deer, the king's wildlife. So you can't just go and take it. You have to have permits, even if it's on your own property. Now, what struck me, though, personally, is that this was a $42,500 bond when it's all added up. Yes, he has the option to go cash with it now at $4,250, so less for sure. But to put this in perspective, yesterday we started out our show with Judge Glazer. She had Antonio Brown, the former NFL wide receiver, in front of her. This guy fled to Dubai thinking he was going to escape charges, got extradited back. He's charged with second-degree attempted murder, and his bond yesterday was $25,000. So 99.9% of the time, I'm personally very much aligned with Judge Mercer. I like him. I think he's one of the closest that we have left to Judge Fleischer in how he handles people. I love how he interacts with family members of the defendants. But this strikes me as egregious to have a $42,500 bond for taking wildlife, which I'm not saying it's right, but that as opposed to this other guy getting $25,000 on a second degree attempted murder charge. I'm just saying, this strikes me as off, but feel free to debate that in the chat. Let's go back to Judge.
So that brings us to Clyde Williams Sr. Mr. Williams, good morning. Mr. Williams, you're here because you've been accused of violating the terms of your state probation. I have a copy of the warrant in front of me, Mr. Williams, and it has no bond on it, signed by the circuit judge. So, Mr. Williams, what I'm going to do this morning is I'm going to get you a lawyer appointed. I'm going to arraign you and get you a lawyer appointed if that's what you're asking for in this VOP charge. Would you like to have an attorney appointed to represent you, Mr. Williams?
Yes, sir.
I'm going to appoint the public defender's office of the 14th Circuit to represent you. Listen to Mr. McDaniel, and we'll see if you have any questions in just a minute.
Your Honor, we're going to enter plea of not guilty. He has to set this on the December 4th pretrial docket, and I advise you, Mr. Green, and come by and talk to him prior to that agreement.
Mr. Mitchell?
Nothing for the state, Your Honor.
So, Mr. Williams, December 4th will be your court date. Your attorney, Mr. Green, will see you before that court date. Do you have any questions?
No, sir.
Have a good day, sir.
Have a blessed one.
Thank you. We have Rhonda Wetstein. Ms. Wetstein, good morning. Ms. Wetstein, you're here because you've been accused of one count of possession of methamphetamine and one count of obstruction by a disguised person. I've read the complaint. There is probable cause. Ms. Wetstein, when I looked at your history, there's a very recent charge in Calhoun County that first appearance sheet shows a bond being set with a condition of random urinalysis. And it also shows, but it doesn't show how you got out. Their file doesn't. Is it safe to assume that you posted bond in Calhoun County?
Yes, sir, I did.
Okay. I figured that. It's just that bond has not been put into the court file yet. So, and I also asked the jail, or asked Mr. Goodson to see if the jail could get a urinalysis this morning, because that was a condition of her bond in Calhoun County. Were you able to get a urinalysis, Corporal?
Not yet, Your Honor.
Okay. So, Ms. Wetstein, I'm going to set you a bond in these cases today. There is probable cause in the complaint, but because you're already out on bond, listen carefully. Mr. McDaniel, anything on behalf of Ms. Wetstein first?
No, Your Honor.
Mr. Mitchell?
Just that she be subject to the same random UAs in this case.
So, Ms. Wetstein, your bond in the possession of methamphetamine in Jackson County is going to be $10,000 cash or surety. Your bond on the misdemeanor is going to be $5,000. Your bond today is $15,000, but don't try to post it, because I'm going to hold you 10 days because it appears you're already out on bond in Calhoun County. I'm going to ask Mr. Mitchell to notify the Calhoun County authorities of your arrest, and we'll see what they do in 10 days. They may or may not revoke your bond. That'll be up to the judge down there. If you do post bond here at any point, you will have a condition of random urinalysis. So, is it 10 days or 7 days?
I thought it was 7
I think we changed it. The judges agreed to change it to 7, so we'd have some uniformity a few months ago. So it's 7-day hold, not 10. I will see you in 7 days, Ms. Wetstein. If that 7 days falls on a weekend or holiday, it won't though. So I'll see you in 7 days, and we'll see if they have a warrant or not, and we'll go from there. Do you have any questions?
No.
All right. Wish you the best now. We are gonna give her a court date, but let's just give it to her when we see her again. Elizabeth Muccio, perhaps. Ms. Muccio, am I pronouncing that correctly?
Yes, sir.
Ma'am, you're here because you've been accused of one count of possession of controlled substance and one count of possession of drug paraphernalia. There is probable cause, ma'am, for those charges. Ms. Muccio, the criminal history I've been provided shows no prior history.
I've never been in.
You've got an Alabama address. It doesn't show anything at all. Have you ever been arrested or charged with a crime before?
No. No, sir.
Okay, thank you. That's great. That's helpful. So let me see what the attorneys have and we'll go from there. Mr. McDaniel?
We just asked for release option, Your Honor.
Mr. Mitchell?
We're fine with a reasonable bond as long as random UAs are a part of the condition.
I think the allegation, Mr. McDaniel, is possession of a single pill.
Correct.
I didn't have that.
I understand that. That's the allegation. How do you pronounce that? Alprazolam? How do you pronounce that?
Xanax.
Alprazolam? Same thing as Xanax. So, ma'am, given the circumstances and the allegations, and especially your criminal history, I'm gonna let you pick between a bond and a conditional release. If you want to accept the conditional release, I'm going to offer you a conditional release. If you want to accept the bond, your bond's going to be $5,000 on the felony and $2,500 on the misdemeanor. That's $7,500 total. Either way, you're going to have a condition of random urinalysis. So you can accept the conditional release or you can post the bond. That's entirely up to you. Do you have any questions, ma'am?
She'll take the conditional release, Your Honor.
All right, so I'm going to grant you the conditional release. The jail's going to give you a notice, or actually the conditional release officer is going to give you a notice. Who gives a notice for a court date? The jail does it, don't they? The jail's going to give you a notice for your court date on your next felony court date, and when will that be? December the 2nd will be your court date at 8:30 a.m. in front of Judge Garcia. That's the date you need to be in court, and the jail will give you that notice before you leave the jail. You'll get to use the phone, ma'am, like you heard me tell the other conditional release or probation case, whichever it was. Ma'am, you'll get to use the phone before you leave the jail. Then you will call friends or family if you wish. You'll get dressed in your regular clothes. You'll be brought to the jail, courthouse to meet with a conditional release officer, and you'll be free to go. If you call friends or family for transportation, tell them you can be picked up at the courthouse in 30 or 45 minutes. Do you have any questions?
No, sir.
All right, ma'am.
I go to Alabama then?
Yes.
Okay.
I never pause hearings. You guys know this, and I've paused this one twice now, just so we're all clear. She took conditional release, which means she's going to have more supervision and stuff like that over the bond. But her bond was $7,500 for a single Xanax pill. A Xanax pill. That's two bonds now that don't make sense to me out of this court this morning, and I love Judge Mercer. There's a reason why I go to him almost every day. I think he's a good guy, but damn, this makes... Look, and you all know, too, if you've followed me for any length of time, you know that I am very anti-drug. Even marijuana bothers me. That's me. But $7,500 for a Xanax is extreme. I'm not sure what we're seeing today, but not a fan. Anyways, let's get back to it.
Mr. Your Honor, did you say that random UAs were part of her conditional release?
I did.
Okay.
I did say random UAs. Okay. So we're back to Courtney Richardson. Miss Richardson, good morning, ma'am. Again, you've had a chance to think about the terms and conditions of the potential offer. Mr. McDaniel, where do we stand?
JK changes or same thing, I think. So, Your Honor, I spoke with Ms. Richardson again, and I've talked to her about it, and between these hearings and whatnot, she just wants to go ahead and take care of it this morning. So the offer I put on the record a while ago will be the offer she's going to plead no contest to.
Ms. Richardson, now that you have more time to think about it, is this what you want to do? The same stuff, same terms that were put on the record earlier. Is that what you want to do?
Yes, sir.
Okay, and I think I even got to the point of putting the sentence on the record, didn't I?
Yes,
correct. So it'll be the same sentence that was previously imposed, 11 months, 29 days probation, $1,078 court costs and fines, a judge guilty, substance abuse counseling at least twice a week, or completing it, as we mentioned earlier, with the DUI school enrollment within 60 days, 50 hours of public service work, Do recommend the minimum driver's license suspension, possible early termination. Ms. Richardson, your parents are still in the courtroom, and as I told you earlier, and I may have told them, usually it's a 30 to 45-minute process. Get her processed out, get her back here and closed, get her to the courthouse. The probation office is inside the county judge's office downstairs. She'll be there in 30 to 45 minutes to be picked up. Okay. Try to get everything done early, Ms. Richardson, so you can get off early. Do you have any questions?
No, sir.
Family have any questions? All right. Wish you the best, ma'am. Yes, sir. Mr. McDaniel, that's everything I had on my first appearance list. Anything else from the public?
I never say this either, but I'm glad that's all he has. I love Wade Mercer, but that was two things that I wholeheartedly disagree with. And, I'm supposed to be like the conservative guy in the crowd, and those bothered me. Let's continue with our 9 to 11% more of Judge Boyd and go back to San Antonio.
And what's the MTR about?
So he's got a couple of another ones, Your Honor, that our understanding is they are out of another jurisdiction, and Lauren's spoken to the prosecutor out there, and they would prefer us not to put on evidence of their cases to protect the record on theirs. And since we have no other allegations, we have nothing to go forward on.
All right. And what alleged county is this?
Nueces County, Judge.
Nueces County. And how far is, Corpus? All right. Thank you. All right. So you all are asking that the motion be withdrawn?
Yes, sir.
Are there any additional conditions you feel need to be added?
Judge, Lauren and I kind of talked about this, and to be quite honest, we're at a loss of what conditions need to be added. I would suggest maybe GPS.
What do you feel you need to be successful on probation? Because as soon as I get this, I'll be able to, let me see, you're charged with evading arrest, detention with a vehicle. Was this a deferred adjudication?
Yes, ma'am.
Yes, so it was a deferred adjudication. So you're looking at 10 years in the prison if your probation were revoked.
Yes, ma'am.
So they're withdrawing this. But what do you need to be successful on probation?
Yeah, I'm fine. Well, rehab. Yeah, rehab.
You say rehab, but what's your issue?
Drinking.
And that's all?
Yes, ma'am.
Are you employed?
Yes, I was.
Doing what?
Amazon. I was working at Amazon.
Okay. Do you have any children? Sorry, what?
Judge, may I?
Yes.
He completed state ISF September of 2024. He did 92 days there. The recommendation that was originally on his TAP evaluation was for safety. I don't see any other conditions to really address any type of addiction issues or anything like that. I do show that he has not completed his aggressive driving course. And there are a couple no contacts. There is permission to transfer to Nueces County. I believe that's where he lives.
So he can't be placed in any type of inpatient treatment because he has these pending cases.
That's correct, Judge.
And as far as what is the alleged complainant's name on the cases out of Nueces? What is the alleged complainant's name on the cases out of Nueces? What is the complainant's name? The person you're accused of committing a crime against, do you know their name?
Sorry,
I'm sorry, what?
Tyree,
Tyreek?
Tyree,
Tyree what?
Lockett.
All right, so we'll need to do a no contact order with that person. And if you could call the prosecutors there and find out what the name is. And so it will be a no contact with that person and you let probation know. And then we can, he says he has an alcohol problem. We can do the sober support meetings or either outpatient treatment. And was he on gang evaluation there? Okay, so let's alternate amend conditions. And are they allowed to do GPS there?
After I looked over it, Judge, with it being in New County, he would have to like do the GPS from, if you're still having him permission to transfer there, you would have to do it there, not here.
All right.
I think he's remanded without bond in Nueces, so he's not getting out anytime soon, most likely.
Okay. So there'll be no contact with the complainants. And you'll give us the name of that person?
I'm looking at the keys number. I can't say.
Thank you. And then we'll do supportive outpatient treatment.
Upon release.
Yes. And then if you can see if they'll give him partial GPS there for employment only. And then if they don't do that, then they don't do that. Is there anything else that you need?
No.
Probation, is there anything else?
Judge, I would say the 30 sober support meetings in 30 days.
All right, there'll be 30 sober support meetings in 30 days, and that's upon release. But they may have it where you can do it at the jail. I know they have classes at the Bexar County Jail, and at Nueces County, they may have courses for you. So what's going to end up happening since this has been withdrawn, you're going to be transferred back to Nueces County. When you're released from there, you need to immediately contact your probation officer upon release. If you're released at 1 a.m., you need to contact them next business day. If you do not, that's going to be a violation of your probation. You understand? All right. Is there anything else?
No, Judge.
All right. Thank you. All right. Thank you.
Maybe excuse, thank you.
All right, let's change it up. Let's go back to Judge. Yeah, let's go to Judge Stevens.
Thefts. Anytime you steal a pack of gum, it's a felony from the rest of your life. Do you understand?
Yes.
That's what you got yourself into. And there's a way to avoid that. In fact, you were even convicted in this court
No monthly.
in 2012.
No monthly expense. Okay.
So you're facing up to 2 years in the state jail if convicted here. Today.
Wait. Judge, I need 4 weeks to serve the home media and the.
I like that case.
Okay, you know how to reach her?
I gave her a card.
You know how to reach her?
Yes, sir.
Okay. But she's not gonna look for you.
Yes,
She's
sir.
gonna have to,
I'm not.
you're gonna have to contact her and get with her because she's most important to your freedom.
Yes, sir.
Okay. All right, we said 4 weeks on that, right? David Snedden. David.
Oh, no.
25C or 1369 is called you, David Ryan Snedden. Is it Snedden?
Snedden, yes, sir.
And you are you still living in Florida?
No, I live in Las Vegas.
All right, let's get your right address here because I have Deltona, Florida last.
And I have lived in Florida in about 8 years, sir.
I don't know what to say about it, but that's what they have on the indictment that was handed up in September. For whatever reason, that's the identification that was used by the DA's office. They had some reason, they just didn't make it up. So something is in data somewhere that shows your old address. What is the new address?
5270.
Unit
264. That's Las Vegas, Nevada, and zip code's 89103.
What's that address in Las Vegas?
52.
Testing you to see if you caught on.
Yeah, I got one.
Oh, I got that corrected today. Were you just driving through town or something?
Yes, sir. I was driving from Florida back to Las Vegas. My
On
father,
Interstate 10?
yeah.
Shouldn't use that one. There are,
Actually, I think I was on a side road because I was stopping at somebody's house in Conroe on the way. I think I was on like a side highway. I don't remember exactly what road I was on.
all right, so this must be interesting. The probable cause affidavit states that this was a product of a road rage incident. And so you ended up being indicted for the second-degree felony of aggravated assault with a deadly weapon. A metal rod was apparently used here in this event, which is defined as a deadly weapon if it has the capability to cause serious bodily injury or death. That's the way it is in Texas. And
Sure, I was the
don't
one who
interrupt.
was stabbed.
Don't interrupt. It's not a, this isn't a trial. I'm just going to tell you what you need to know about this and just listen intently. But you're accused of using a deadly weapon, and in Texas, that's the way a deadly weapon is defined. It can a firearm is a deadly weapon, or any other device that is capable of causing serious bodily injury or death. Which I'm looking. This is the way it's worded here exactly in this environment. That's the legal definition of a deadly weapon. So the people who investigated the case and then the grand jury that reviewed it here in Jefferson County and indicted you, they believe there was probable cause that occurred. Takes more than that to convict somebody in this state. It takes beyond a reasonable doubt, but probable cause is all it takes to arrest or file an indictment. So a second-degree felony, if convicted, means you're facing no less than 2 no more than 20 years confinement in prison, and a fine up to $10,000 can be assessed. But it doesn't stop there. Paragraph 2 of this indictment states that you were previously convicted in 2007 out of California. It says the felony of making a criminal threat. I've never heard of such a crime. But California's laws, are differently worded than Texas.
Not in 2007, so that's wrong.
Well, once again, it's not a debate. I'm just telling you right now what you're charged with. So what you're facing, you're going to have to deal with this. This states you were convicted in 2007 in California of that crime. If that were true, if you were convicted of the second-degree felony of aggravated assault, and if it was proven true that you have a prior conviction, then your punishment range steps up 1 degree.
Okay.
You're in Texas and in probably most, if not all states. The punishment range, it involves the criminal history as well as the circumstances of the case. Those are the 2 factors. So criminal history states that you were previously convicted. If that were proven true, that second degree felony punishment becomes first degree felony punishment, steps up 1 degree, which would mean that you would be looking at no less than 5 nor more than 99 years in prison or life imprisonment and a fine up to $10,000. So needless to say, this is very serious. Only capital murders are worse than first degree felonies in punishment here in Texas. So what do you do for a living?
I'm disabled.
Will you have some kind of an income from the government in some way?
I don't.
You don't even get that?
No,
So what are you doing driving around in a Cadillac? Goodness.
I don't have a
Oh,
Cadillac.
no, what were you driving?
I have a Volkswagen Tiguan,
How many miles on it?
175,000.
Okay, so over in Indian River in Las Vegas, is that where you grew up?
No, I grew up in Florida. That's how they got the Florida accent. I haven't been in Florida since 2018.
Why did you select Las Vegas?
All the wrong reasons.
Oh.
I moved there with a girlfriend at the time. And long story short, she
Okay.
decided she didn't like Vegas.
It's always
and
girls' fault.
took off.
According to guys. That's what happens up here.
Rejects that assumption.
So I moved there with a girlfriend. She didn't like it and she left me there. And at that point, I was already stuck.
Thanks. Okay. Well, this lady is going to try to help you. And I'd follow her advice. What we're going to do is 4 weeks. I'll give you
Yes.
resetting 4 weeks to see where we stand on everything. Make sure you stay in contact with her, Mr. Stanton.
Yes, sir.
You're heading back to Las Vegas soon?
Honestly, I don't know. It all kind of depends on this. To be completely honest with you, there's a chance I may go ahead and go to Florida from here and just because Florida's a lot closer to Jefferson County than Las Vegas. I mean, I left my house at 9 o'clock Monday morning and just got here at like 9 o'clock last night. So it's almost 2,000 miles each way from my house to the courthouse.
I'm looking at this, the probable cause affidavit that was prepared by the investigators in this case. And what they call it is a product of what they deem to be a road rage incident between two parties. You had a big metal rod. She had a machete. That must have been an interesting moment to see how that was playing on East Tex Freeway. Oh, I'll get a resetting 4 weeks, okay? John Washington is next. 24 CR 545, John Washington.
Swear our family information was document is true and correct?
Yes.
Yeah.
Well, I did it for me now, and I was at home. If I also.
Okay, you are Mr. Washington?
Yes, sir.
And you've been here before?
Yes, sir. Yes.
So where are we?
I called down to your office and asked how would I be able to get a court appointed lawyer? I've been trying to get a lawyer. And I'm out of town.
Why should the taxpayers pay for your mess? You know, this is one of those things that grownups have to deal with, and we're responsible for our mess. The taxpayers don't find it amusing when other people make mistakes or accused of mistakes and they're paying the way. That's not the way it works. Why aren't you independent?
No, I'm not. It's because of this case, and I'm getting arrested is caused me to lose my job and be in a hardship.
Where were you working?
General contractor.
How did this cause you to lose your general contract? I mean, Did you lose a license or something?
My license, and I was in jail for a month.
Just for being charged with this?
Mhm.
That's not the way it should work. You have a prior conviction is the problem.
Yes.
Out of 2013. But you were contractor with that prior conviction, right?
Yes.
You resolved that. Here, you're just charged with a crime. You're not convicted of it.
Okay.
Well, they call that the presumption of innocence. Well, that's the way, that's in the Constitution. Well, it's the law.
I'm fighting both of those. I mean, another one was it was a rental car. It was a mistake, but it's a rental car.
But once again, you're not deemed guilty. You're presumed innocent. So I don't understand who took your contractor's license away?
The company that I was working for.
Swear or on the commission.
They took that, there was I was a general contractor with them.
Okay, what was the people involved in this and who were alleged to be the victims here, or was that in that business?
No.
Enterprise Leasing or somebody else?
That's a rental car.
I understand what that is, but that's who they say or is the victim here. But that's not who you were contracting.
No.
Who were you contracting?
Affordable contracting service. I had a military contract.
Okay, it's a military contract. Okay. Well, probably for security, the presumption of innocence doesn't apply when it comes to the military.
Yes, sir.
And their need for security. So, but nonetheless, you still have the ability to do a job. Did you fill out this indigent form?
No, sir.
I need to fill that out and I'll review it and deem whether you're worthy of being appointed lawyer. Okay. She's gonna give you a copy of that and then just fill it out and then you just need to swear in front of her and then I will review it. Okay.
Yes.
Thank you. Braden North.
Right, here was one of those pins, just go sit in over there, fill it out.
That's you?
Sir.
Okay, you are charged with a state jail felony of forgery. You're out of town too, huh? From Hallettsville?
Yes, sir.
You still live there?
Yes, sir.
Well, if I mean, basically, I'm gonna do something, you won't have to go after it. You have to be.
All right. You are charged with the state jail felony of forgery, which carries with it up to 2 years in prison if convicted, and it's a felony offense. Are you getting an attorney? You need one. The whole act is on video. You may know. You're in a bad spot.
Then if I can reset it, it can get my attorney.
Are you able to hire somebody?
Yes, sir.
I'm gonna give you 4 weeks. You're gonna get a resetting, but give them this copy of the resetting so that they know when you have to be back here. If you don't have a lawyer, you gotta be back here. If you don't have one, You gotta be back here and you gotta be back here anyway, unless you hire a lawyer and they say, I have taken care of the resetting. You don't have to come back. But hire a lawyer first, give them that resetting, you let them advise you from there, okay? But you or your lawyer have to be here on that next setting, okay? All right, get a resetting from that lady, thank you. I have, time.
All right, let's per Ashley's request, let's take a look at Mindy Glazer, see how she's holding up since we are approaching lunchtime in Miami.
I'll set it at, do the other one, $1,500 and doing the same. Count the use of an anti-shoplifting device. He's the one who had main possession of it. Be $1,000. Count for, I don't know, $1. It's not his child. It doesn't have to be his child. The child's tagging along with his dad, the co-defendant, watching him steal. You want $1 on that one?
Yes,
$1, count for. Have a nice day. It's page 15. Sir, you were arrested for grand theft of a vehicle. I will appoint the public defender's office for you. There's probably cause for grand theft of a vehicle. He has an open trespass. I don't know if it was possession of cannabis and resisting. So he jumped out of the car while it kept moving. The door lock to the car was completely removed. The ignition was damaged. It had a flathead screwdriver with grease on the top of it inside, in the floorboard. The ignition had the same grease. Yeah, I think I'll set the bond, $2,500. Have a nice day.
Would you consider any program at all, Judge?
No, you gotta go see the individual judge, Judge G. Maybe she will, but I'm not. He has misdemeanor. George Alvarez, good morning, sir. You were arrested for, is it English or Spanish? English, good?
Spanish.
Spanish, please. Sir, you were arrested for false imprisonment, attempted tampering with physical evidence, domestic battery by strangulation, and aggravated battery, and simple battery. Sir, can you afford to hire a lawyer?
Señor, usted lo han arrestado por privación de la libertad, por violencia intrafamiliar por medio de estrangulación, agresión física con agravantes. ¿Usted tiene los medios para contratar a un abogado particular?
No sabría decir.
I wouldn't be able to tell you that.
Well, how much money do you make a week?
¿Cuánto usted gana a la semana?
1,300, 1,400.
1,300, 1,400.
A week?
Yes.
¿A la semana? Yes.
So that's over $50,000 a year.
Son más de 50,000 al año.
I don't believe you qualify for the public defender's office because you earn too much money.
Me parece que no califica para que lo represente el abogado de oficio por la cantidad de dinero que gana.
You want me to reset this case to give you an opportunity to hire a lawyer? Or do you want to waive a lawyer's presence and I'll proceed now and set a bond?
¿Usted quiere que le aplace su caso para que tenga la oportunidad de tener un abogado presente o quiere renunciar a eso ahora para que le dé una fianza?
No fianza sí puede.
Yes, a bond if you can.
I don't think that with a hair dryer is an aggravated battery. It's a battery.
No me parece que esto califica como una agresión física con agravantes, es agresión física. I'm sorry.
I'm saying that there's no problems. I'll go through the counts where I find probable cause.
Le voy a repetir dentro de un momento todos los cargos para los que haya un motivo fundado.
So you were ordered to stay away from the alleged victim, Anadis Rios.
Señor, se le ordena mantenerse alejado de la víctima Anadis Ríos.
No contact with the victim, either directly, indirectly, in person, in writing, by telephone, or through third parties.
No puede tener contacto o comunicación con la víctima, ya sea de manera directa, indirecta, en persona, por escrito, por teléfono o mediante terceros.
No contact with the victim through social media or other electronic means.
No puede tener comunicación con la víctima por las redes sociales u otros medios electrónicos.
And you must stay at least 500 feet away from the victim, her home and school, and place of employment at all times.
Y debe permanecer al menos a 500 pies de la víctima, lugar de estudios, lugar de empleo y su hogar en todo momento.
Do not engage in any criminal activity. Do not use or possess illegal drugs.
No se involucre en ningún tipo de actividad ilícita y no use o esté en tenencia de drogas ilícitas.
Do not use, purchase, possess, or carry a firearm, gun, weapon, or ammunition.
No use, compre, esté en tenencia de o porte arma de fuego, municiones o armas blancas.
You must immediately surrender any firearms, ammunition, and any concealed weapons permits to the nearest police department and file a receipt with the court.
Debe entregar inmediatamente cualquier arma de fuego, munición o permiso para portar arma oculta a la estación de policía más cercana y traer recibo al tribunal.
You may return to the victim's residence one time only within 48 hours of your release from jail.
Puedes regresar a la residencia de la víctima una sola vez hasta 48 horas después de su liberación.
You must be accompanied by a police officer.
Pero solamente en compañía de una escolta de policía.
So that you retrieve your personal clothing, health items, medication, personal and business-related paperwork, and work tools.
Esto para ir a buscar cualquier tipo de efectos personales, incluyendo ropa, medicamentos, documentación y herramientas de trabajo.
If you go to the victim's home without the police or if you stay there, you will be arrested.
Si se presenta en la residencia de la víctima sin la policía o permanece allí, será arrestado.
Do you understand? Stay away.
¿Entendió la orden de alejamiento?
If the victim moved out of the home and is not living there, you're allowed to go back. But if she's still staying there, you have to find somewhere else to go. Do you understand?
Si la víctima se ha mudado y no está viviendo en la residencia, usted puede quedarse allí, pero si ella continúa, usted tiene que buscar otro lugar donde quedarse.
Okay.
Okay.
So count one, false imprisonment, there's probable cause.
Para el cargo número 1, privación de la libertad y motivo fundado.
I'll set that bond. What do you want? Lower the bonds instead of 1,500 or 1,000? Okay. $1,000 bond, count one.
$1,000 de fianza por el cargo número 1.
Count two, the attempted tampering with a victim will be $1,000 bond.
Por el cargo número 2, intento de influir a una víctima. That was 500, Your Honor.
1,000.
$1,000 de fianza.
Count three, there's probable cause for domestic battery by strangulation. That bond will be $4,000.
El cargo número 3, hay motivo fundado para violencia intrafamiliar, estrangulación, $4,000 de fianza.
Count four, aggravated battery, no probable cause, release outright.
Cargo número 4, agresión física con agravantes, no hay motivo fundado, será liberado.
Count five, battery is $1,000 bond.
Cargo número 5, agresión física, $1,000 de fianza.
So your total bond is $7,000.
La fianza total es de $7,000.
All right, have a nice day.
Que tenga buen día.
That's your man.
Thank you, same to you.
Okay, Judge Glazer seems to be holding up better than expected, given that we're in the witching hour over there. Let's go back to Judge Boyd. Let's do that. Let's make that happen.
The record?
State.
And are you Mr. Valderas?
Yes, ma'am.
All right, so are you all proceeding with your contested hearing? All right, so I'm showing you, Mr. Valderas, what is entitled Motion to Enter Adjudication of Guilt and Revoke Community Supervision. Did you review that with your attorney? Did you understand it?
Yes, Your Honor.
Are you the same Daniel Ramos Valderas who's placed on deferred adjudication in 2024? Thank you. CR 2985 for the offense of unauthorized use of a vehicle on June 24th, 2024 for a period of 2 years. Is that you?
Yes, Your Honor.
All right, state.
Violated condition number 1, on or about the 23rd day of August 2025 in Kendall County, Texas, the defendant Daniel Ramos Valderas committed the offense of evading arrest in violation of condition number 1.
How do you plead to that? True or not true?
True, ma'am.
State will waive the remaining.
Any objections?
No objection, Your Honor.
Did you understand by pleading true to violation of condition number 1, the court could find it true, grant the motion, find you guilty, and sentence you up to 2 years in the state jail facility and up to a $10,000 fine?
Yes, Your Honor.
Knowing that, do you still wish to plead true to violation of condition number 1?
Yes, Your Honor.
Court will find violation of condition number 1 true. Is there a proposed agreement?
Yes, Judge, the proposed agreement is to grant state's motion, enter an adjudication of guilt and sentence to 14 months in the state jail facility.
All right, and what is happening with the evading arrest case and the theft case? Oh, those are out of Kendall?
Yes, Judge, I spoke with the Kendall County prosecutor and was given permission to plead true to this evading, and then they asked that all the others be handled in Kendall County.
All right. Could you raise your right hand for me, please? Do you solemnly swear or affirm the testimony you give will be the truth and nothing but the truth, so help you God?
Yes, Your Honor.
All right, you can lower your hand, state your name for the record.
Daniel Ramos Valderas.
All right. So what have you done since you've been on probation?
I completed 9 months of GPS monitor with no violations. I was given 120 hours of community service, but was waived if I would to get my GED or diploma. I got my high school diploma. I completed my theft court class, level 2. My UAs, I was coming out clean. I only had about 1 negative UA. Other than that, I haven't had no violations my whole time on probation. While I was on monitor, no violations as well. I was on curfew on time, was paying all my monthly fees on time, and I was also employed as well, working my whole time, and I was basically done with everything on probation. Just I was just waiting for my officer to. She was going to request the early termination on probation, but we never fell through with it.
All right, probation is what is the information he's given me true? So where did you go wrong? I don't want you to talk about your other cases because I don't want you to cause your other attorney to not have certain defenses.
Yes, ma'am.
But I'm trying to find out if there was something else we could have done for you where you would have been successful.
I mean, I was pretty successful myself. I feel like I just put myself in a situation that I wasn't really I just wasn't in the right state of mind at the time, and I wasn't thinking about the consequences at the time, and I was just around some people that really were just not part of my circle or anything.
And what did I tell you about consequences and making better decisions?
Yes, Your Honor.
So are you asking me to follow this agreement?
I mean, I would like to get reinstated, but if I can't, I mean, I would.
No,
like you
and,
to
and
get-
let me just tell you why, because I don't like people to think that I just do things haphazardly.
Yes, Your Honor.
The reason why is number one, you have these other cases that are pending from another county. So there's nothing, no class that I can give you because you're going to be in limbo because you have these other cases out of the other county.
Yes, Your Honor.
Okay. So, how much time does he have in? Does anybody know? All right, thank you.
It was August 23rd that he was, since he was a kindergarten.
Okay. But I can tell you, if you don't start making better decisions in your life is going to be over. How old are you?
20 years old.
You're 20. I can tell you based upon my experience, once you hit 21, everybody thinks, yay, let me have my first drink. I'm 21. Let me celebrate. But once you hit 21, the years start coming so fast. You look up, you're in your 50s. And if you don't get back on the right track, it's not going to go well for you. You're going to end up becoming institutionalized. You're going to end up in somebody's prison. I don't know what's going to happen with those cases in the other county, but even in those other cases, if you end up going to prison or end up going to jail, do not become institutionalized. Get back on track. Whatever they do with those cases, if they sentence you to length of time, guess what? It's not a permanent sentence, right? At some point you finish it. So don't go, if you end up in prison, don't go there, start getting face tattoos and all of that, because that eliminates certain jobs that people would even been willing to look at you to hire you.
Yes, Your
Or
Honor.
either you're gonna end up spending a lot of money on concealer. Okay?
Yes, Your Honor.
All right. All right, are you asking the court to follow this agreement?
Yes, Your Honor.
Are you waiving your right to appeal?
Yes, Your Honor.
All right, so this is what the court is going to do. The court is finding violation of condition number 1 true. The court is going to revoke find you guilty. There's to be no contact with Kevin, Ricardo, Alvarez, Sandoval, Maybelline, Ashley Cortez. And the court will sentence you to 12 months in the state jail facility, give you credit for any time served. And the only reason why I'm doing that is because you truly have done a lot on probation. And if they were going to request for early termination, if everything would have been completed, I would have given it to you. All right, I'm showing you what's entitled Trial Court Certification of Defendant's Rights to Appeal. Did you review that with your attorney? Did you understand it and sign it?
Yes, Your Honor.
Because this is a plea bargain agreement, because I followed your plea bargain agreement, and because you waived your right to appeal, you do not have the court's permission to appeal. Because this is a felony conviction, you're not allowed to own or possess any weapons or ammunition. If you have a question over what that is, you'll need to speak to an attorney. Do you understand?
Yes, Your Honor.
All right, good luck to you. Make better choices.
Thank you, Your Honor.
You're welcome.
Okie dokie, friends. Let's change it up again. Let's go see what Kentucky justice looks like. Let's go to Judge David Williams' court. We haven't been there in a while.
Commonwealth of Kentucky versus Stephen Brown, 23 CR 0063, 24 CR 005, 25 CR 001. You are Stephen Brown.
I am.
You were born in 1980. Last 4 digits. Now, I've received a motion that says that you wish to enter a guilty plea today. Is that correct?
Yes.
Okay, are you currently under the influence of drugs or alcohol?
No.
Is this plea freely and voluntarily given?
Yes.
Are you the same person that I just previously identified in these 3 cases?
Yes.
Is your judgment impaired, sir, in any way?
No.
Have you discussed this matter with your attorney? Are you satisfied with his advice?
I have.
Have you reviewed the evidence the Commonwealth has against you? You feel like you're fully informed about your case? Okay, you do not have to enter a guilty plea today. You have certain rights under the Kentucky and United States Constitution, sir. I'm gonna go down through those rights. If at any time you want to step away and consult with your attorney, you just signal that, okay? You have a right not to testify against yourself. No one can make you say anything. Right to speed, jury trial. The right to be represented by counsel at your jury trial. The right to confront and cross-examine all witnesses called to testify against you. The right to produce evidence. The right to call witnesses in your favor. Have process issued to compel their attendance. You have a right to appeal this matter to higher court if you lose, and a right to require the Commonwealth to prove beyond a reasonable doubt that you're guilty of charge against you. Understand that by entering a guilty plea today, you give up all those rights. You understand that? Yeah, I may consider the Commonwealth's recommendation, but I may apply any range of sentence provided below. I don't have to accept the recommendation. Prior to accepting your recommendation, I will await a pre-sentence investigation report done by probation and parole. In the event that I don't accept the Commonwealth's recommendation after having reviewed that report and decide to impose a harsher sentence than you've agreed to, you can withdraw your plea and proceed to trial. You understand that?
Yes.
Mr. Hunley, are you going to present that? Will you step to your left, gentlemen? Step to your left. Mr. Hunley, what is the Commonwealth's recommendation?
Your Honor, upon a plea of guilty to trafficking in a controlled substance first degree, namely fentanyl, the defendant shall receive a sentence of 8 years to serve at 50% parole eligibility. The 8-year sentence shall run consecutive to McCracken County indictment number 17 CR 0005, consisting of 3 years. The defendant shall receive credit for time served. Commonwealth opposes any form of probation and agreed that any evidence in the case be destroyed consistent with the laws of the Commonwealth.
Is that your understanding?
Yes.
Okay.
And Your Honor, I'm sorry to add to that. There's 2 other cases that are on for revocation that he is not going to be revoked on. So, this is demanded as well, because this occurred before those.
That would be 005 and 0063.
I believe so, yes, Your Honor.
They weren't mentioned in that plea agreement.
That's correct, but he's also on for revocation. And
I know they're not mentioned in the plea agreement.
Jesse, and he's not going to be revoked on his other cases.
We need to withdraw those motions.
That's correct, because I didn't realize this crime occurred prior to those cases.
Okay, so I just want to get that on the record.
Thank you.
So there's no revocation in 63 or 005 because the crime to which he's entering a plea now predates those.
That's correct, Your Honor.
Okay, it's on the record. Okay.
Thank you, Your Honor.
Yeah. Are you pleading guilty in these acts charged in the indictment because you did commit the acts? Is that correct?
Yes.
Okay. Doing so of your own free will. Knowing your constitutional rights is still your desire to give up those rights, enter plea of guilty to charge, allow the court to fix your punishment. Is that correct?
Yes.
You understand that after entering a plea of guilty, any future convictions can be enhanced on a persistent felony offender law. Is that your signature on the document there?
Yes.
You see that you have the document, right? Okay. I'll accept the agreement. Now, was he a state prisoner?
I don't think he was.
No, so we'll have to do a pre-sentence investigation report and schedule the sentencing on December the 15th. Okay.
Yes, sir.
Okay. Thank you very much.
Thank you, Your Honor.
Yeah. Christopher DeWeese.
Yeah. Don't go
Okay,
back.
Marion County Jail, we'll be right with you. We got one, this is the last case before them. Commonwealth versus. Y'all are keying that microphone real bad, okay? Commonwealth versus Christopher DeWeese, 25 CR 0028. Are you Christopher DeWeese?
Yeah.
Born 1969?
Yes.
Last 4 digits. Pre-trial conference.
Yes.
Your Honor, I think we're going to take a plea today. I think Mr. DeWeese would, I think, like to set it for the 15th of next month, just because he's had some medical complications.
You want to do it, go ahead and do the plea and we can schedule Senate.
I understand he's had complications and we've continued this foreign advice. He's here. He just had to report to probation parole. But the only thing we'll have to do after the police. So I don't see any reason to let it off.
I think that's reasonable to do.
And Your Honor, the only other issue is this is his first felony. We wanted to try to get diversion, but that wasn't offered. And so,
Well,
No, just based on the facts of the case.
well, I mean, he's gonna enter a plea that,
Yeah.
you know, a motion been tendered says you wish to enter a plea today. Is that correct?
Yes.
Are you currently under the influence of drugs or alcohol? Are you currently under the influence of drugs or alcohol?
No, sir.
Is this plea freely and voluntarily given?
Yes, sir.
You're the same person that we just identified as far as the last four digits of your social security number.
Yes, sir.
Is that correct? Is your judgment impaired today in any way?
No, sir.
Have you discussed this matter with your attorney? Are you satisfied with his advice?
Yes, sir.
Have you viewed the evidence the Commonwealth has against you? Believe you're fully informed about your case?
Yes, sir.
You understand that you do not have to enter guilty plea today. You have certain rights under the Kentucky United States Constitution. Before I can accept a plea, I need to know that you understand those rights.
Yes, sir.
I'm gonna go over. If you want to stop at any time, step away and talk to your attorney, you can do that. You have a right not to testify against yourself. No one can make you say anything. Right to speedy trial by jury, right to be represented by counsel at your jury trial, the right to confront and cross-examine all witnesses called to testify against you, right to produce evidence, the right to call witnesses in your favor, have process issued to compel their attendance. You have a right to appeal this matter to higher court if you lose, the right to require the Commonwealth prove beyond a reasonable doubt that you're guilty of charge against you. Understand that by entering a guilty plea today, you waive those rights. You understand that?
Yes, sir.
Now, I may consider the Commonwealth's recommendation that I may apply any range of sentence provided below. I don't have to accept the recommendation. Prior to accepting any recommendation, I'll await a pre-sentence investigation report from probation and parole. In the event that I do not accept the Commonwealth's recommendation and decide to impose a harsher sentence, you have a right to withdraw your plea and proceed to trial. Do you understand that?
Yes, sir.
Mr. Hunley, are you going to present the Commonwealth's recommendation? If y'all will step to the left there a little bit.
Okay. Your Honor, upon a plea of guilty possession of a controlled substance first degree, namely meth, the defendant should receive a sentence of 3 years probated for 5 years with the probation supervised. The defendant shall be referred to a social service clinician and follow any and all recommendations of the clinician. He shall receive credit for time served, and again, as a part of the probation requirements, shall obtain gainful employment or do a minimum of 30 hours a week community service. The defendant agrees that any evidence in this case be disposed of in accordance with the laws of Commonwealth.
Mr. Reed, is that what you agreed to?
Yes, sir.
Okay. Are you pleading guilty because you did commit the acts charged in the indictment as amended?
Yes, sir.
You're doing so your own free will.
Yes, sir.
Knowing your constitutional amendments explains that still your desire to give up these enter plea and allow the court to fix your punishment when the range permitted by law.
Yes, sir.
You understand that after entering this plea, future convictions will be enhanced in a persistent felony offender law. You understand that?
Yes, sir.
That's your signature on the offer in motion.
Yes, sir.
I'll accept the agreement. Order pre-sentence investigation report to be done by probation and parole. Your sentencing will happen on December 15th. Since the Commonwealth has proposed probation and because of your injury or your problem, I'll allow you to stay free on bond until then under the same conditions. Okay, meet with the probation and parole officer.
thank you, Your Honor.
Okay, Barron County. Okay, let's start out with Matthew Bowles. Matthew Bowles.
What's a good phone number? 8637.
Are you Matthew Bowles?
Yes, Your Honor.
You have an attorney, Mr. Bowles?
No.
I'm gonna appoint public advocate to do the arraignment for you, then they can do it. Has he filled out any paperwork, see if he's eligible? They've got your paperwork here. Let me look at it just a second. Well, I'll take a look at, see if he's eligible and temporarily appoint Office of Public Advocacy. Mr. Bowles, you have a right to remain silent. Were you born in 1989?
Yes, Your Honor.
That's 1-3. The
Yes,
grand
Your
jury of, the grand jury of Monroe County has charged you with flagrant non-support. You know what that is, don't you? You know what the charge is.
Yes, Your Honor.
Okay, you acknowledge the identity of your client, receive the indictment, waive formal reading and arraignment, enter plea not guilty, reserving all pretrial motions.
Yes, sir.
Okay. I'm signing a reciprocal discovery agreement where your attorney will be given the information that the Commonwealth has to help you prepare to defense. Mr. Stockton, it looked like there was like $6,000 and something in this case here. Is that right? There's a lot more than that. Okay, well, we'll have a negotiation day on December 5th and the next court date is on December 15th. Okay, Mark Bowles. Mark.
All right, let's change it up again. Let's go back to Judge Stevens, new contestant.
So. You're charged here with a DWI. Operating a motor vehicle while intoxicated. Last year, right about Christmas time. Because you have 2 prior DWI convictions, then this turns into, from a misdemeanor, it's a felony automatically. Anytime you commit a DWI, it's a felony. So you're looking at no less than 2, no more than 10 years confinement in prison, and a fine up to $10,000 can be assessed. But it doesn't end there. You have a robbery conviction in 97 here in this criminal district. Before I was here. After that was final, it is alleged in paragraph 4 here of this indictment that you committed the felony of illegal possession of cocaine, a 3rd-degree felony, and you were convicted of that in Harris County. So you, according to this indictment, are what we call an habitual felon, which means if convicted of this, you are facing no less than 25 years in prison to life in prison. No less than 25 to life. The least you can get is 25. There is no probation here.
How old are you?
For 25 or above. So it can't be any more serious. This also states last time we were here, you said you were hiring an attorney, did you? You said you were.
Yes. No. Expect of money. My old man over there just got approved for the loan.
Who?
For.
I thought you said an old man.
No, well. Oh.
I know that's a term, but he's your father. Show respect. Yes, sir. Then he's also paying your way out of this mess. You need to respect him, but you need to also respect the law. And or else you get in trouble, like any of us would. Do you understand how serious this is? This is very serious. So how much time do you need to get an attorney, you think? Or your father to pay for it? I'm going to give you 2 more weeks. Can you do that in 2 weeks? All right, get a resetting. It's 2 weeks. Where are we on that?
No. 2 weeks is no
Does
good,
2 weeks mean 3?
basically.
Because Thanksgiving week, we'll be shut down during Thanksgiving. And that's coming up in a couple of weeks.
Yes.
Okay, 3 weeks. All right. Okay, here, get that. Thank you.
Barbara, thank you for gifting a membership. I very much appreciate that. And Lady Jax, congrats on 3 months. Thanks for hanging with us the last 90 days. It's so great to have you with us.
I'm on the 11th actually.
No, declare you indigent, and an attorney will be appointed to represent you. Make sure you know. You don't have to follow their advice, but they're there for a good reason. They're your lifeline to get out of trouble. Don't get any crime committed while on bond can result in a revocation of your bond. So you don't want to pour gas on this fire, right?
Yes, sir.
And I find that the defendant has zero income and an attorney will be appointed to represent you. Okay, thank you. Get a resetting. Thank you. Juwan Toler was reset. John Foray was reset to this afternoon's docket, and Rod Owens was also reset. These are Dustin Elmo's cases.
Thank you.
I'm jumping to Charles Moss next. I'm gonna need some files. Charles Ray Moss. Mr. Moss.
Thank you.
He's in custody. Mr. Gertz is visiting with.
All right, well, they locate the next contestant. Let's go back to Judge Boyd because she has a fresh contestant in front of her.
For sentencing, you entered a plea of no contest to the offense of robbery. According to your plea bargain agreement, punishment is to be assessed at a cap of 6 years in the prison. There's a $2,000 fine. State is silent on your application. There's a restitution amount that is listed as $2,000. However, in the PSI report, it states that they have not been given proof of any restitution, but that's what you all have agreed to. Taking consideration 2025 CC 003927. Have both parties had a chance to review the PSI report and TAP evaluation?
I have not, Your Honor. But I believe we're silent, so I don't anticipate having much comment on it.
Any objections?
No objection to the PSI, Your Honor.
All right. Do you have any witnesses?
No witnesses, Your Honor.
Anything you wish to say on behalf of your client?
Yes, Your Honor. We have applied for deferred adjudication. This is Ms. Gonzalez's first offense as an adult. She's young. She's just applied for the ability to go back and obtain her high school diploma that's starting on the 18th. She's currently employed. She has a place to stay. This was a very large lapse of judgment, which she understands. She understands the consequences of her actions. And if the court is willing to grant her the deferred adjudication application we've put in, she understands that even one little toe over the line carries with it some very significant consequences. Judge, we'd ask that you please grant our application for deferred adjudication and allow Ms. Gonzalez to prove to this court that she can be a productive, non-offending member of society.
All right, Jonah, raise your right hand for me, please. Do you solemnly swear or affirm the testimony you give will be the truth and nothing but the truth, so help you God?
Yes, Your Honor.
All right, you can lower your hand. State your name for the record.
Brianna Gonzalez.
All right, you need to speak up, so.
Brianna Gonzalez.
All right, so why did you do this?
Your Honor, I made a mistake. I was hanging around with the wrong crowd and.
No. Let me just tell you, don't do I was hanging around with the wrong crowd, because if that other person were before me, they would say they were hanging around with the wrong crowd. And I would say, who is that? And you know who that would be? You. So why did you do this?
I wasn't thinking right. I was being dumb and ignorant.
Well, this person is supposed to be your friend. Is that not true?
No, Your Honor.
That's what it says in the stipulation, that they knew you. And this person gave you and the other person who you were with, who was your friend, a ride. And then you said, well, you know what? I just want to talk to them with us two alone. And then that person got out of the car so you could speak to them. And then you immediately get out of the car, get in the driver's seat, take off and hit that person with the vehicle. That's what the stips are. So why would you do this to a person who's supposedly your friend?
Arguing at the time, Your Honor.
No, it doesn't say anything about you arguing with him in the stips. What it says was, victim works as a taxi driver, gave his friend, that's you. So since they say friend, I'm assuming that you all have a prior relationship and he considers you a friend. So he gave you a ride and your other friend a ride. So your friend with a taxi driver and you have your friend with you and he gives you both a ride. And I'm assuming he was doing this out of the kindness of his heart. Did he charge you guys any money?
No, Your Honor.
All right. So he gives you a ride and you go to apartment complex and you tell him, I want to speak to my friend in private. So the victim gets out of the vehicle and then you immediately jump into the driver's seat and drive away. The victim gets hit by the vehicle that you're driving. And it says the victim had pain on his left knee from the vehicle hitting him. The defendant, that's you, struck the apartment complex gate, tearing off the front bumper to the victim's vehicle. So again, why are you doing this?
Your Honor, I was drinking that day.
I don't understand how drinking makes you do this. Because how did you end up even getting a ride from him? Did you pick up the phone and call him?
No, Your Honor, we were all under the influence at the pool, at the apartment complex, and went to go pick up more alcohol, and that's when I took the car.
No. I mean, there has to be a point where he's giving you a ride.
No,
Where
Your
does that come in?
We left from the apartment complex, Your Honor. It was me, my friend, and Moji. We were there at the apartment complex, and we all took off from the apartment complex, and we all left. He didn't give us a ride. We were all just riding together.
Okay. And then what happens?
I took off in his car,
Why?
Your Honor, because I wanted to leave where we were at and I wanted to get back home, and we were arguing that same night. We had got into an altercation with my other friend.
That's not what the stips say. The stips say that you told him that you wanted to speak to your friend in private.
No, Your Honor, we didn't speak in private. We were all right there with the windows down.
No, I'm just telling you what the stipulations say. So why do you think I should give you probation and not send you to prison?
Your Honor, I'd like to get my life together and change my ways. I was a troubled teenager for my grandparents. Grew up in the CPS system, and I always ran away. And I feel like me getting myself together would be better and change my ways so I can accomplish my goals and work and continue taking care of my grandparents.
All right. And do you have any children?
No, Your Honor.
Thank goodness. So you said you grew up in CPS?
Yes, Your Honor.
So where are your parents?
I don't talk to my mom or my biological dad, Your Honor.
So you're just living with your grandparents?
Yes, Your Honor.
And who all lives with the grandparents?
It's me and my grandparents.
All right. Anything else?
No, Your Honor.
All right. And if you're drug tested today, what would the results be?
Your Honor, I smoked last night.
All right. And did you smoke at your grandparents' house?
No, Your Honor.
Where did you smoke?
Yesterday I went out with friends.
See, you're still making the same choices. And if you're coming to me and you want probation, the least you can do is come clean and sober. And you're not even doing that. So you're still making the same choices that are not good choices. So when you're smoking marijuana, are you going to tell me you were with the wrong people
No, Your Honor.
or hanging out with the bad crowd?
No.
You're part of the bad crowd. And do you have employment?
Yes, Your Honor.
What do you do?
I work at a range.
What does that mean?
Uh,
What do you do?
I take score of like when they shoot the rifles, and I take care of my grandparents on the side also.
All right, so that taking care of the grandparents, you're not doing a good job. So that's not going to be there. So you say you work on a range. So what are they shooting?
They're shooting like little birds. You push the button and they shoot.
Oh, it's the fake birdie things.
Yes.
And so what is your job?
I sit down and I just, I'm a referee pretty much.
Okay. And does that pay enough to support you?
Yes,
And is that a full-time job?
it's part-time.
All right. So you're going to have to get a full-time job. You understand? And your grandparents, they're letting you stay there. So their rules apply. And if you want me to give you probation in this case, you're going to be on GPS.
Sure.
Is there anything, State, you wish to say? I know you're silent. I don't know if there's something you wish to say with regards to facts.
Your Honor, I know that the defendant had her recitation of the facts and the court is reading the facts from the STIPs. We don't have any information that the STIPs are inaccurate, so that's what I'll rest on.
Okay. All right, thank you.
Yes, ma'am. I also have a dismissal for you.
Oh, this is county court.
no,
You'll have
you're
to
right.
take it
The
there.
misdemeanor.
Yes.
I forgot about that. Thank
No
you.
problem. All right, probation. What conditions do you believe can help her? We obviously have drug issues. Bad decision making.
Outpatient, it is recommended along with some support needing the regular random UA. I would also include more recognition therapy.
All right.
I know that she has her high school diploma.
How far did you go in school?
8th grade, Your Honor.
She's
Why did you-
she's starting her program on the 18th, Judge.
All right, why did you drop out of school?
I was in CPS. They were taking me from foster home to foster home.
Okay. Oh. Do you need any type of therapy?
Yes, Your Honor. Yes, Your Honor.
All right. So if we can do some sort of trauma therapy, I've done a lot of CPS cases before in my career as a defense attorney, so I know that there are issues. And I know a lot of times children get moved from place to place, and that's a bad thing because you've already been separated from your family, and whether your family is good to you or not, you love them. And then you get moved to a new place, and then a new place, and then a new place. Do you have siblings?
Yes, Your Honor.
And were you all separated? And have you had any contact with them?
Just got back in contact with them, Your Honor.
All right, so I don't know how your siblings are doing, but do not bring drama and conflict into their life. You had a bad start in life, and the reason why you've had a bad start is because you've been in CPS care, right?
Yes.
So you're gonna have to turn things around and break the cycle. Please do not go out here and start having children until you are able to support yourself and support children. You understand?
Yes, Your Honor.
And do not choose some random guy to be the father of your child. You understand?
Yes, Your Honor.
And is there any gang affiliation with you?
No, Your Honor.
Okay. All right, probation, this is what I'm gonna do. 6 years deferred adjudication. There's to be regular reporting by Zoom or in person, regular random UAs, proof of employment within 45 days, no employment as a home healthcare provider or with minors. Field visits 1 time per month until further notice. Intensive outpatient treatment with probation. I'm going to ask that with the UAs, test for levels, those levels had better start going down. You understand?
Yes, Your Honor.
The MRT, take in consideration 2025 CC 003927. A $2,000 fine that will be probated. There's to be restitution to and no contact with Mojib, MOJIB, Rahmani, RAHMANI, and the restitution amount is $2,000. Probation, I'm going to ask for 200 hours of community service restitution. 100 of those hours will be waived upon completion of GED or trade school certification. The remaining community service hours you'll need to do. You understand?
Yes, Your Honor.
Probation, do you think we need GPS?
I don't think it's.
All right. Is there anything else we need probation?
No, I just want to know, are you getting a position for her to get the principal?
No, because sometimes I would tell you, sometimes I realize some people are not good test takers, right? So what I'm telling you, if you obtain your GED or if you get a trade school certification, I'll deduct 100 hours of your community service restitution. Do you understand?
Yes, Your Honor.
All right. And then probation, if possible, some type of trauma therapy for her, please, to address CPS issues. All right. Is there anything else you need from the court to be successful?
No, Your Honor.
Did you review the document entitled Trial Court Certification of Defendant's Rights to Appeal with your attorney? Did you understand it and sign it?
Yes, Your Honor.
Because this is a plea bargain agreement, because I followed your plea bargain agreement, and because you waive your right to appeal, you do not have the court's permission to appeal. Do you understand?
Yes, Your Honor.
All right, we can go off the record. Here's the thing. Everybody, I can guarantee you, your attorney has probably had bad things happen to him. Nobody has had a great life where they've just gone through and their life has been perfect. But you can overcome it, but you're going to have to fight to overcome it. You understand?
Yes, sir.
And at some point in time, the fact that you were in CPS care, the fact that your parents didn't do what they needed to do, at some point in time, your choices become your own. And what I can tell you in this court, since you're on probation, at this point, you can put it on a calendar. Any choices you make, those are going to be your own choices. It's not going to be my parent did this or my parent did that. You understand?
Yes, sir.
In this court, to be successful on probation, communication is key. If you have an issue, let your probation officer know about it. If you feel they're not addressing it, you can come back to court, okay?
Yes, Your Honor.
And here's my advice to you. I have no problem with tattoos, right? But if you want people to look at you and want to read your book for employment, you're going to have to stop with the face tattoos and stop with the piercing of the face. And let me just tell you why. Because if you come in for a job, some people are not going to take the time to look beyond this, right? They're just going to say, I don't think that person will be good. And they're going to move on to the next person. And you don't want that. You want people to get to know you and then say, yeah, this person is going to be great. All right. All right. Good luck to you.
Thank you.
You're welcome.
Thank you, Your Honor.
As a man who has hired hundreds of people over the years, Judge Boyd speaks the truth. First impressions, you only get one shot at that. Let's go to Louisiana. Let's make that happen. There's somebody, looks like a witness is going to appear from a car, so that for some reason always tends to get interesting.
Parole panel. And on the panel this morning, my colleagues here in Baton Rouge is Ms. Carolyn Stapleton. Joining us remotely by Zoom is Mrs. Jerry Ledoux. We are at DOC headquarters in Baton Rouge, so I'd like to ask the staff here to please introduce yourself for the record.
Carla Williams.
Francis Abbott.
And our first remote location this morning is at Claiborne Detention Center. And I believe we have Mr. Como before us.
Yes, ma'am.
Mr. Como, would you introduce yourself? Tell us your name and DOC number.
My name is Merlin James Como. My DOC number is 441810.
All right, Mr. Como. Let me acknowledge the guests that we have here who are here in support. And their sisters, 3 sisters, Montessa Como, Andrea Como, and Katrina Como. And so we'll ask for their comments shortly. First, I'm going to read some identifiers into the record, and then I'll ask you if that information is true and correct. And then I'm going to turn it over to Mrs. Ledoux because your case has been assigned to her this morning. You ready?
Yes, ma'am.
So, Mr. Como, you're classified as a second felony offender. You're currently serving an 18-year sentence. You were sentenced in Acadia Parish in January of 2011 for 1 count of indecent behavior with a juvenile, and your parole eligibility date was November 30th of 2018. You don't earn good time, so your full-term release date is November 29 of 2027. Is that information correct?
Yes, ma'am.
All right, Mrs. Ledoux?
Yes, good morning. Mr. Como, have you served 15 of your 18-year sentence?
Yes, ma'am. I'm coming up on 16 years.
Coming up on 16. And I was a little confused reading your report regarding the classes you've taken. I saw where you had started phase 1 and 2 of the sex offender treatment, but were you removed for disciplinary reasons? And have you ever completed that course?
I was removed because where I was taking the class at, a table had got destroyed, and my name, I was written up for it, but they couldn't provide footage proving that I did that, so they just kicked me out the classroom and never reinstated me. You know, and those write-ups were dismissed.
And so have you requested to be
Yes, ma'am.
back
I
in
have
this
requested. Yes, ma'am. I have requested right after I was kicked out of the class. You know, I asked to be reinstated, and they had transferred me over here.
and they don't offer that at the facility that you're in, correct?
No, ma'am.
Okay. So you have one count in this particular case. Was this an isolated incident, or because I have the record, just to be honest, was this an isolated incident?
Yes, ma'am.
Okay. I don't see in your file any transition plan to return to society. So what were your thoughts about that? Because I know you have to have an approved residence plan for the particular crime that you're on. So what are your thoughts on that?
Well, my family, my three sisters that support me, you know, they have housing that they have did research on that I will be able to go to. Plus, prior to my incarceration, you know, I was in the transportation industry, and you know, I would like to go back to that, but you know, I understand I might have to start at the bottom, you know, and work my way back up, you know. So, but for the most part, you know, I've learned a lot on this during my incarceration. You know what it is to be resilient, what it is to have discipline and be patient, no matter what trials and tribulations I may face and go through. It's not what I go through; it's about how I respond to it.
So I didn't delve real deeply into your disciplinary conduct because you have been write-up free for the last 3 years. But how many DBs do you have in your jacket?
I don't have none that I'm aware of because I've been over
Okay.
here at this facility for going on 5 years in January, and I haven't received a write-up.
Okay. Okay. Are there any members of the staff there who could speak about, so what is your job? What is your job currently?
I don't have a job at this facility, and
Okay.
you know, it's just, I
They don't have
mean,
anything for y'all to do. It's just doing time.
yeah, it's just doing time. I mean, they do have trustees in positions and stuff like that, but you know, I mean,
Can you have,
I guess I don't, you know, I'm not with the politics. You know, it's political.
okay. So you never took pre-release or substance abuse?
No, man. When I was in Allen Parish Correctional Center, I was taking NA and AA and stuff
Uh-huh.
like that. But that was in like 2015 and 16. But I got transferred from there.
Okay. Okay. I'd like to hear from your sisters at this time. Um, who wants to go first?
I can.
Which one? Yeah. Okay.
I can go first. I'm sorry, I had some issues unmuting my phone. Good morning. My name is Tessa. I'm Merlin's younger sister. And actually, I have actually been doing research. I spoke with a couple of people. There's 2 homes in where we live. There's one in Lafayette called Sober Living. There's also another one in New Iberia that houses strictly sex offenders. I've been in very close contact with both of them. They're both waiting for me to respond after this hearing. We have a bed already ready. I've looked into the programs. I've also spoke with Miss Ethel, who has an outreach program here in Lafayette that I'm sure you guys are familiar with. The homes that I've spoken with, they are fully vetted with the Louisiana Board of Pardon and Parole. So they both said that he would qualify. They were looking into some more information. Miss Ethel Thibodeau with Beacon Connections, it's a community outreach. She's prepared to help with sex offender fees, housing. We have a lot of resources. My other sister who's actually on the phone, she works for a similar program, a day program, and she also has a lot of resources. So we've gotten information on just like curfew, the programs, different things that's offered in these homes, different type of support groups. There's also one in Lafayette called Sober Living where they have to go to church and they have to receive therapy so many times a week. They have to find a job. So I have a lot of information that I can send over to you guys if you would like. But we've definitely been looking into things and just trying to help him to transition back into society because I know it's going to be a challenge being that he's been in there for a while. But we're willing to help however we can.
Okay, great. Thank you very much.
Yes, ma'am.
And the next person, which other sister wants to speak
I'll
now?
go. I'm Chandrea Como, ma'am. How you doing?
Good.
Well, I'm his younger sister, and I have a CDL license. My brother also, he held a CDL license before he went in, and we looked into the process of getting his fee. A lot of fees have been waived because he's incarcerated. So I think now his balance to get his license back is like $800. They just waiting for him to get back to go to the DMV to get on a payment plan. And I have jobs, like I have a lot of connections with jobs to get him back rolling. I know he can't go like far out. He got to stay like in the city or whatever, but I have a lot of connections with jobs. They just need him to get out to fill the application out. We have a lot of connections. People are willing to help him.
Okay, great. And the last sister, sorry, I don't have a name in front of me.
Hi, good morning. My name is Quatrina Como, and I thank you for allowing the opportunity to speak on behalf of my brother Merlin. I just want to say that my brother has been incarcerated years, and during that time, he has reflected deeply on the choices that led him there. Through these years, I've seen a real change in him, not just his words, but in his attitude and the way he carries himself. He's grown in faith, humility, and gratitude, and he truly understands the seriousness of his past and has taken full responsibility for his actions. The man he is today, not the same man who entered the system all those years ago. My brother often speaks about wanting a second chance, not only to rebuild his life, but to also be a positive influence on others. He hopes to use his story and his experiences to teach other young men who may be heading down the wrong path and to help them understand that every decision matters and that redemption is always possible through accountability and change. He is committed to becoming a productive member of society, to work, to give back, to live a life of integrity. And all he is asking for is the opportunity to show that the lessons he's learned were not in vain, and that no matter what mistakes a person has made, it's never too late to change. As his family, we will continue to support and encourage him as he takes the next steps in his journey. I know he can't change the past, but I also know that he's truly remorseful and he's ready to move forward in a positive and a meaningful way. I thank you for your time and for considering his request for parole.
Thank you. Well, I would say, Mr. Como, that you are extremely blessed to have the sisters you have. And they have spoken very positively about you, but I want to hear from you. What have you learned during this time about your behavior that sent you to prison? And I mean, we've read all the details. So you tell me, what have you learned?
I have learned that, what it is to, live a life on life's terms. Prior to my incarceration, I was abusing, cocaine, and I was making choices, that led me here. And I understand that, and as I got older, I got wiser, and you know, rehabilitation, a lot of these places they don't offer it, but it really starts within. You have to take accountability and responsibility for your actions. And nobody's perfect. We all have our flaws, but I understand what it is to be a man. I understand what it is to go through things and how to respond to it, and I really have learned my lesson and things like that. I'm not a violent individual. I'm not a career criminal or anything. And, I'm willing to do whatever it takes, to reintegrate back into society and to be that member, to take care of my family and my loved ones that has been there for me for all these years.
Yeah, well, talk to me about about the impact on your victim. I mean, that's one thing I haven't heard any of your sisters talk about, or you. I want to know what you've come to understand about the victim impact.
What I come to understand is that the victim, has suffered, mental anguish. And since then, the victim, we have, put our differences aside and, forgiveness, I was forgiven and things of that nature. And, I'm really, remorseful and sorry for my actions, my crime and everything, and I understand that, what I did, was not right,
How
and
not right? How not right?
it wasn't right by the laws of the land,
It's not right morally either. It's not
morally.
right
Yes, ma'am.
as a father. It's not
Yes,
right.
ma'am.
Okay. Um, I'm going to allow my colleagues to ask some questions. I want to reserve to be able to come back. But if my colleagues would like to ask some questions.
Yeah, I mean, I follow along the same path as Miss Ledoux. When she asked you the questions about what do you think about your victim, you talked only about yourself and that you're forgiven and all of this kind of stuff. But I don't think you have a clue what that must have done to that child at all. So even all these years later, I don't think you've reflected on how bad what you did was. So I just, that's all I have to say about it. I don't see any changes there.
I'm sorry, ma'am. Is it okay for me?
No, ma'am. No, ma'am. I'm sorry. Mr. Como, you've been before the parole board twice. You were denied both times in 2018, 2021, and the reason stated each of those times was the need for sex offender treatment, because at that time you hadn't had it. So you've had phase 1 and 2, right?
I took phase 1, 2, and 3, and I went to came up for parole in 2023, and they said I had victim opposition, which was untrue.
Right. I did see there's no victim opposition today, but your record that I have only shows phase 1 and 2.
No, ma'am. I took phase 1, 2, and 3, and I was testing out. I was at the end, and
You must not have got credit for 3 if that's when all that stuff with the table happened. Maybe they didn't give you credit for 3. Do you have contact with your daughter or her mother?
Yes, ma'am. My daughter, she wrote me a letter and she told me, she needed me, to be in her life. Yes, I am in contact with her.
And do you Well, that's all I have for now. Ms. Ledoux, you want to follow up?
Obviously, Mr. Como, you have to have pre-release prior to release. That is just one of the requirements that the state has put into place. And that has not, do they have pre-release where you are?
No, ma'am.
Okay. And there's some things that are missing in the puzzle piece. I think that with the completion of your sex offender treatment and your pre-release, then that gives me the confidence knowing that that's been completed. And the support that you have from your family, obviously they've worked very hard to come up with that. Let me tell you one of the things that the way I think about this is that you're going to be off paper in 2027. And if you are released in 2026, you will have time on supervision. That the Department of Correction will be able to supervise you and know how you're reintegrating. Does that make sense?
Yes, ma'am.
Have you been on supervision before?
I was on probation. This was way back in like 2000, like 2000 to 2001.
Yeah. But you have to understand this is going to be a very intense supervision. Okay. With no option if you ever got out before your full-term date. I'm prepared to vote. I'm going to vote to grant your parole conditioned upon completion of the sex offender treatment and pre-release with approved plans and with increased substance abuse testing and a curfew. I want to have this period of supervision so that because you have no victim opposition, there's no opposition to your release. You obviously have support. Your evidence-based evaluations are good. So I think that this period of supervision with some additional would be helpful for my mind. So that's my vote today.
All right, thank you. Mrs. Stapleton?
Well, I agree with everything Ms. Ledoux said. I mean, she's put on some very good conditions, and that would be necessary because you are fixing to get out. It's not a long time. So that would ensure that you would continue your treatment plan. And so I concur with Ms. Ledoux.
All right, Mr. Como, I do agree. We need, documentation that you complete the sex offender treatment. We'll send you back probably to buy you door sheets so you can finish that program. Do you understand the other conditions that Ms. Ledoux laid out?
Yes, ma'am. It's just the pre-release. Will I have to take that over there too, or I'll be transferred somewhere else?
They have it. I think they have it there.
Okay, so y'all gonna make sure that I get transferred to these facilities because it's nothing that I can do on my own.
I know, but we can get that done.
I would like to add that I think you only should have supervised contact with the victim while you're on paper. I think that needs to be a supervised contact so that we understand and you understand that that's a you're not to be alone with the victim until you're off paper.
Yes, ma'am.
All right. So, well, you got a little bit of work to do, Mr. Como. But you've been great. Go, sorry.
Do you understand how? Do you know like how long would it take like for me to be transferred over there?
Well, we're just going to make the request to DOC, and we don't have any particular sense of how long it'll take. But usually they do it as quickly as a bed is available. So Good luck to you. That concludes our business there at Claiborne.
I'm not going to play a denied or approved stinger there because honestly, it's a little bit of both. Can't go now, but maybe later. So be it, I guess. Where do we want to go? Let's go back to Judge Simpson. It's been like 9, maybe as much as 2 hours since we've seen him. Let's go there. Oh, Barbara, thank you for the 5, by the way. Very much appreciated. Thank you so much.
Thank you, Honor.
Hopefully we can figure something out with what we're talking about. Thank you.
I'll text you, Miss Akins.
Okay,
Thank you, Ms.
thank you.
Court calls the case, People versus Trita Guyton.
And Mary Rubio on behalf of Ms. Guyton, who is approaching, and here she is. I'm standing in for the attorney of record, David Burgess, with her consent. Is that correct?
Yes.
Okay. Could you please state your name?
Trita Guyton.
And Your Honor, I was told that the court should have the plea form. Also.
I do.
Okay.
I have a plea form. I don't know. Is this going to be a guilty plea?
Yes. That's my understanding from speaking with Ms. Guyton.
All right. The plea form indicates that the defendant would be pleading guilty to an added count 3 of use of cocaine, the 1-year offense. Upon a successful plea to that charge, counts 1 and 2 would be dismissed. That's the court's full understanding of the agreement. The sentence waiver was not checked. She understands I'm taking the plea, but not sentencing.
Correct. I did go and explain that to her, and I explained that it's my understanding that it is typical that there is a pre-sentence report so that she would have the report and be sentenced at a later date in front of a different judge.
All right. But that's a correct statement of the resolution of the verdict. All right. May I have her sworn?
Raise your right hand. Do you solemnly swear and affirm the testimony you're about to give will be the truth, the whole truth, and nothing but the truth, so help you God?
Yes, I do.
State your name.
Trita Guyton.
It's this court's understanding that you're going to be pleading guilty to the charge of use of cocaine. That's a misdemeanor punishable by up to 1 year incarceration and $2,000 fine plus court costs. Is that your understanding?
Yes, sir.
And you understand that?
Yes, yeah.
All right. You understand also that while I'm taking your plea, I would not be your sentencing judge, as we talked about. You'd be sentenced before Judge Washington in the 14B District Court. You understand that?
Yes, sir.
All right. Still wish to plead guilty?
Yes, sir.
And to that charge, how do you plead?
Guilty.
And you understand that by pleading guilty, you'll not have a trial of any kind.
Yes.
Counsel, I don't have an advice already.
Oh, I'm sorry. I really apologize. I thought everything was already in the file. Okay.
You think she did it?
I think so.
Can I see that?
Ma'am, did you sign an advice of rights form previously? Yes, she did. I got it.
Okay.
You remember signing one?
Yes.
Any questions regarding any of those rights?
Yes, sir.
All right. Look on the podium. Please look at paragraph 5. Those are your rights which are part of a trial. You understand? Pleading guilty, you'll be giving up those rights as well as all the rights contained on that form.
Yes, sir.
You understand you're giving up your right to appeal of right.
Yes, sir.
Are you on probation or parole?
Probation.
All right. Were you on probation at the time of this offense?
Yes.
All right. I do have to advise you that your entry of a plea in this case could be considered a violation of that probation. You understand that?
Yes, sir.
And if it is considered a violation, that other court could sentence you to the maximum allowable under that other charge or charges. You understand that?
Yes, sir.
Understanding that, do you still wish to plead guilty to this charge?
Yes, sir.
Anybody promise you anything other than what's been stated here today on the record to get you to plead?
No, sir.
Anybody threaten you or coerce you?
No, sir.
You're doing this voluntarily
Yes, sir.
and of your own free will?
Yes, sir.
All right. And also because you believe you're guilty?
Yes, sir.
Only date, really, people. Putting together this file. On the date of March 12, 2024, Holmes Road near Twin Tower Street, Ypsilanti Township, Washtenaw County, State of Michigan. Did you have cocaine in your possession?
Yes, sir.
Had you used it?
Yes.
Did you know what you were using was cocaine?
Yes.
All right, ma'am, I do have to advise you that if you commit misconduct as defined by the Michigan court rules between the time of my acceptance of your plea and the time of sentencing, The court would not be bound by any sentence evaluation or recommendation, and you would not be entitled to withdraw your plea. You understand that?
Yes, sir.
Is counsel aware of any other promises, threats, or other inducements which have led to this plea?
I am not.
All right. And have I complied with the court rule, and would it be proper to accept this defendant's?
Yes, Your Honor.
Yes, Your Honor.
Court will accept the defendant's plea of guilty to count 3. Counts 1 and 2 are dismissed. Pre-sentence investigation and report is ordered at 14B probation. Sentencing in this matter will be
December 11th at 10 a.m.
December 11th, 2025, 10 a.m.
Your Honor, may I address bond?
That is before Judge Washington, briefly.
Your Honor, it's my understanding that Ms. Guyton has been remanded, and I understand that's kind of due to her own actions, but I did want to just advise the court that I've spoken to Ms. Guyton. She has a lot of health issues, including cancer and blood clots. She has not had her medication for her blood clots. She indicates that she was participating in, and if she is released, she would continue to participate in the substance abuse program through Huron Oaks.
All right. And we went through this a couple of times with this guy. And so I'm not going to change my bond in this case. Certainly after her pre-sentence interview, that can be looked at by Judge Washington.
I understand.
So at this time, her request for bond reduction is denied.
Okay, I understand.
Thank you.
Don't have none at all.
They're going to give you next.
Barbara, thank you for another $5. Really appreciate that. Your continued kindness and support of me has never gone unnoticed. I hope you know that. I really appreciate you.
Kenneth Waters, Assistant Prosecuting Attorney.
Good morning, Your Honor. Zach Binney on behalf of Ms. Baker, who appears via Zoom, requesting permission to practice pursuant to Michigan Court Rule 8.120 under Assistant Public Defender Asli Bashir.
Where's Bashir? He's not even here.
In that case, under Assistant.
You're gonna pick another one?
Assistant
Oh,
Public
no, go
Defender.
ahead. Pick one. Let's enter here. Who?
Stephanie Cannon, Judge. Oh.
People with
Yeah, I don't know that that's gonna work. I don't know. I don't know that I can grant that. Permission to practice is granted.
Thank you, Your Honor.
Mr. Brown's coming up, and he's not like he is not trying to step in. He's just here.
Ms. Baker, can you please state your name for the record?
Melinda Baker.
Thank you, ma'am.
Your Honor, we would request an adjournment for negotiations with the people.
Probable cause conference will be adjourned December 11th, 2025, 9 a.m.
Thank you, Your
5 will
Honor.
continue. Thank you.
Thank
Thank you, Ms.
you.
Baker.
Thank you.
Court calls the case, People versus Tamarian Jones.
Morning, Your Honor. This is Justin Andrews. This is Justin Andrews.
Counsel. Up there, I don't see you, but go ahead, counsel.
Yes, Your Honor. Justin Andrews, P 81445, on behalf of Mr. Tamaria Jones, standing in for the attorney of record, Attorney Adam Gregory Clements. Your Honor has set this matter for an exam the 25th of November. Mr. Clements is just asking for that time to be later in the afternoon, as he has a motion hearing earlier that day, Your Honor.
Well, I have it set at noon.
Okay, that should be fine.
All right, so here's what we'll do. You understand that, sir?
I didn't hear.
Didn't hear. Okay. So you're setting it for a preliminary examination prior to your coming out so that the record is clear. They had indicated discovery was complete, and the people indicated that they have their witnesses available. So for your co-defendant, we were dealing with a co-defendant's case. We set it. Your counsel was present at that time.
Okay.
And so we were waiting for you to be able to be brought out, and we're setting the exam at the same time. And he was just clarifying some things regarding it.
Okay.
That make more sense to you?
Yes, sir.
All right. So preliminary examination in person will be set November 25th, 2025 at 12 noon. And that is before me.
Thank you, Your Honor.
All right.
Your Honor. Have a great day.
Thank you. Pardon?
I said, have a great day to you and your staff, Your Honor. Thank you.
All righty. Thank you, sir. Court calls the case People versus Jordan Bishop, Easterling.
Brian Bowling, Assistant Public Defender on behalf of Mr. Bishop Easterling was
Bishop?
approaching.
Never mind.
No relation.
Another person. Your name, sir?
Jordan Bishop Easterling. Judge, I'm asking for an adjournment in this matter as well, as I don't have any discovery.
This is it, Pat. All right, so what I'm gonna do in this case, probable cause conference will be adjourned December 18th, 2025, 9 a.m. All right, sir.
Thank you, Judge.
Thank you. Thank you, sir. Court calls the case of the People versus Sean Grisby. Or it's Gabbries, excuse me.
Christina Costantino appearing with and on behalf of Sean Gabbries.
Oh, she's here.
I am here, Judge.
Oh, you're so short. I didn't see you.
Oh, that's okay.
No, I'm just.
I even wore the heels today.
I know. Well. All right.
Sean, can you state your name for the court?
Sean Gabbries.
Thank you.
You're requesting an adjournment.
Yes, Your Honor. I believe there is some outstanding discovery, specifically some cell phone extractions, a forensic interview that's outstanding, and potentially some body camera footage. Mr. Kennedy and I have spoken about that, so they are aware of that.
Okay, so if I set it for the 11th, can we have all that cleared, or?
I'm not so confident about the cell phone extraction. I don't know how long it's going to take. Body cam and the forensic interviews are easier.
Easier, yeah.
But the cell phone extraction, I sent a text message to Detective Morrison. I would see what I can do about it.
I'd ask that we at least try for that date, given he's in
11th,
custody.
okay.
And if at that point,
And
if
at
we still
that
don't
point,
have
we
it,
can make
then
an assessment as to what, okay, that makes
Sure.
sense. Probable cause conference, December 11th, 2025, 9 a.m. Bond continued.
Thank you, Your Honor.
Thank you, Judge.
Court calls the case of the People versus Bobby Black.
People. Morning, Your Honor. Mike Getty, defender on behalf of Mr. Black, who's here via Zoom, Judge.
Mr. Black. State your name.
Bobby Black.
Thank you. Requesting an adjournment.
Yes, Your Honor. I need to, I have received discovery. I've reviewed it. I need to review it with Mr. Black. He's currently not available. He should be as of the 19th. He's in Kalamazoo at the Enlightened Therapy site.
I'm sorry.
He's in Kalamazoo at the Enlightened Therapy facility.
Okay, so you want something after the 19th, or you want?
Yes, that would be preferable, Judge.
You're talking the 19th of November.
Yes, Judge.
All right, gotcha. All right, well, why don't I set it for the 20th? No, that's next week. We'll set it for the 4th. Probable cause conference will be adjourned December 4th, 2025, 9 a.m. Bond continued.
Thank you, Your Honor.
All right, thank you, Mr. Black. Thank you. Court calls the case People versus Christopher Decker.
Morning, Your Honor. J. Grant Miller, T58658 on behalf of Mr. Decker, who approaches the podium. Please state your name.
For Decker, Your Honor. Sorry.
This is time for a competency review for evaluation.
All right. Yes, Your Honor. We received the report from the Forensic Center. We'll stipulate to their findings as it relates to competency. I don't believe that people are objecting.
And that's correct, Your Honor. Simply, I believe it's the October 6th report.
Yes, it is.
Yes, and I would note that the criminal responsibility report has not been prepared yet, but we expect that will be arriving at some time.
All right.
But Mr. Decker, actually, we've been attempting to
let me make my finding. The report in this case indicates that the defendant is competent to stand trial. Court would find that the defendant is competent, can understand the nature and objects of the proceedings against him, and can rationally assist in his defense. Therefore, he's deemed competent. Counsel, I'm going to need an order when you get a chance to file that.
Yes, Your Honor.
What would you like the court to do with this?
Your Honor, we're requesting an adjournment. This case was tracking another matter that Mr. Decker already had set for trial. And that was supposed to be, I believe, about last week. That got adjourned to January the 9th. And we can't try and resolve this case until that case is off of the table, apparently.
Is that
So-
a circuit court trial?
It is.
Is he being held on that case also?
Actually, he was granted a personal recognizance bond in that case, but we weren't addressing bond yet. I would like to if I could, though.
Go ahead.
Your Honor, in the circuit court case that is scheduled for trial on January the 9th, my client was granted a personal recognizance bond with GPS tether. I know he has a $25,000 bond in this case, and I know the people are going to oppose what I'm going to request. We'd request a personal recognizance bond in this case with GPS tether and no contact with Martin Tingley, of course, but also Ozone, which is a treatment facility out here in Washtenaw County, has a bed for my client. So we're asking that he be tethered to the Ozone treatment facility where he could continue to with his mental health treatment and substance treatment programs that he's been affecting through the jail. He also has been speaking with Tiffany Davis. I believe the court's well aware of her work with the Washtenaw County Sheriff's through community corrections. They have a plan for him, a daily routine set up so he can try and continue with some of the treatment that he's been working with in the jail as best as he could. We're just asking him to have a PR to Ozone with the GPS so he can continue.
Your Honor, I understand he wasn't a PR bond in the circuit court case. It is unusual, but I am going to be objecting to a PR bond here. In this case, this is an assault case. He has two other pending assault cases. He has one in 15th District for an aggravated assault, and then there's the circuit court bench trial in January, which is an assault, great bodily harm by strangulation, as well as domestic violence third.
Who is that case before?
Judge Conlon.
Okay.
In addition to that, I do see a pretty significant and concerning history going back to 2020, including concealing carry of weapons, felonious assault, possession of controlled substances. Obviously, he has at least two prior domestic violences. Domestic violence third. He has a prior fleeing and eluding, resisting and obstructing. I believe he was actually on warrant status at the commission of this offense. And so I'm just concerned with the release of treatment about his ability to remain a safe member of the community, as well as ability to show back at the court.
Isn't that the same concerns that the circuit court would have had?
Maybe I wasn't present for the hearing. I don't know what was put on the record. I don't know if that court had additional information that led it to grant a PR bond. Based on what I'm seeing here, I disagree with that decision. I understand it was made.
I'm sure Judge Conlon cares. Go ahead.
That's my position. I would have released a treatment and change in bond at this time.
But okay.
And I did speak with brother counsel who's handling the circuit court case yesterday in Judge Conlon's courtroom, who indicated that the court did see fit to grant him the personal bond with the conditions of the GPS tether. They actually didn't even require him to go to Ozone under that bond, but he does have a bed available for him at Ozone. And I understand this court's concerns about some of the behaviors in this incident. So that's why we're requesting the GPS to the Ozone. They have a bed for him, and he's already been trying to get in touch with everybody to make sure he stays on a treatment plan if he is released, Your
Honor. In this instance, probable cause conference, I'm going to adjourn. You said that trial is set for January
9.
I'll adjourn this probable cause conference to January 15th, 2026, 9 a.m. I really hate to go out that far, but what I will do, however, is I'm going to grant the motion to modify the defendant's bond. I'm going to release him on a personal recognizance bond with a GPS tether. However, the one distinction between what may be is done in circuit court, he is required to go to Ozone House for treatment.
Yes, Your Honor.
All right. Thank you.
There we go. Okie dokie, friends. It is time to call it a day. Many other things I must go do. But I will be back with you tonight, as will a whole bunch of other people. 8 p.m. Eastern, 5 p.m. Pacific for Sidebar, where we're going to discuss lawyers behaving badly, if I recall correctly. So that should be a hoot. And we'll be back tomorrow for Super Friday, 10 a.m. Eastern, 7 a.m. Pacific, 45 minutes early for channel members. So do join us then as well. Barbara, thank you again for everything you did today. To the rest of you out there, thank you for joining us so much. Appreciate all the interaction in the chat, all the well wishes, all the support, all of it. One quick thing before we go. If you go to the pinned chat, you will see a link for our Discord server. We just spun this up a week or two ago. So quite honestly, if you go there right now, there's not a whole lot going on, but I encourage you to go there, get in at the ground floor, sign up for it. It's absolutely free. But one of the things you get is notifications every time we post and go live, and you're not guaranteed to get notifications with YouTube right now. So as long as when you first sign in, you agree to notifications, you'll get that. And then in the very near future, I don't have an exact date because of other things that are going on here at the bunker at the moment, but in the very near future, we're going to start doing a post-game show for This Morning Live, and that will take place on Discord. So you'll want to be prepared for that as well. So please do give that a look. In the meantime, go have yourselves a great Thursday. Again, look forward to seeing you tonight on Sidebar and tomorrow here on the Morning Live show. In the meantime, take care. God bless.